the last item of the list, my lord, item 48, my lord. There's some urgency in this, my lord. In fact, it was specifically directed to be listed right after vacations, my lord. Can I pray for an upgradation, maybe at 2, if your lordship permits, my lord?
Okay.
I'll in the meantime call for an affidavit. Oblige.
May I please the Lord.
At 2.
At 2.
May I please the Lordship. Your Lordship, I beg to mention item number 16 of today's daily list, Your Lordship. Actually,
16.
16, Your Lordship. SOI was to appear, but she is not well today. Can the matter be listed on Friday, Your Lordship? 1-6.
What is your name?
S. Paul, Your Lordship.
Heard Mr. S. Paul, learned counsel for the appellant, who prays for an adjournment due to personal difficulty of whose difficulty?
S. Roy, Your Lordship.
Of Mr. S. Roy, who is the conducting counsel, of Mrs. S. Roy, who is the conducting counsel in this appeal. Considering the submissions, the prayer is allowed. Let this case be listed again on
Friday.
19th.
Oblige, Your Lordship.
May it please, your Lordship. Also, with the concern on the other side, I beg to mention item number 26, Lordship. Actually, in this case, actually, we have not received the Dusty Service report, Lordship. So we pray for an adjournment of 2 weeks, Lordship, if possible. I'm for the appellant,
What is your name?
SP Sharma, Lordship.
Heard Mr. S.P. Sharma. You have informed the other side.
I have informed the others.
Heard Mr. S.P. Sharma, learned counsel for the appellant, who submits that the report of no service on the respondent through Dusty mode has not been received yet, and on that ground prays for an adjournment for 2 weeks. Learned counsel for the appellant has also submitted that he has informed the learned counsel for the respondent regarding his prayer for adjournment on the ground mentioned by him. The prayer is allowed. Let this case be listed after 2 weeks.
2 weeks, Lordship. Deeply obliged.
May it please the Lordship. Lordship, with the consent of the other side, I beg to mention item 44, Lordship. My senior has some difficulty to conduct a case to the Lordship. We have taken consent of the other side.
What is your name?
44. D. Roy, Lordship.
You are counsel for petitioner or respondent?
Petitioner, Lordship.
Lordship, I am for the respondent, Lordship.
You don't have any objection.
Lordship.
You have no objection.
Yes, Lordship. Taken consent, Lordship. Kindly fix a date.
Heard Miss. No, registry would fix a date.
After 3 years, Lordship.
Heard Mr.
D. Roy.
D. Roy, learned counsel for the petitioner, who prays for an adjournment on the ground of the personal difficulty of the conducting counsel. Learned Mr. What is your name? Respondent.
PJ Doctor.
Heard Mr. P.J. Doctor, who has no objection to the said prayer. Hence, the prayer is allowed. Let this case be listed again after 3 weeks on a date to be fixed by registry.
Lordship, interim order passed earlier.
The interim order shall continue till next day.
Oblige, Lordship.
May it please your Lordship, with regard to item number 13, my lord, I am for the appellant, my lord. 1-3, my lord, 13.
Yes.
Lord, I for the appellant, I have taken consent from the respondent, my lord. The matter may be passed over, it will be adjourned for 2 weeks, my lord. My senior is out of station, my lord.
What is your name?
V.K. Borwa, my lord.
Heard Mr. V.K. Borwa, who prays for an adjournment on the ground that conducting counsel for the appellant is out of station. He also submits that he has informed the counsel for the respondent side. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks.
Hello, Mr. Chair.
May I please, your Lordship. Well, as regards item number 45, perhaps your Lordship may not like to take up the matter. And in this matter, I am along with Mr. R. Dalita.
Item number 45. List this matter before any other bench except me.
Lordship, I beg to mention item 53 of today's supplementary list, Lordship. I appear on behalf of Mr. B. Sharma for the railways, Lordship, and he has got some difficulty today,
53.
Lordship.
53. We have taken consent of the petitioner, Lordship.
You are for railway.
Lordship, on behalf of Mr. B. Sharma.
You have informed the appellant's counsel.
Yes, Lordship.
Heard Mr.
I am MP Sharma.
Heard Mr. MP Sharma, who prays for an
2
adjournment.
weeks. Lordship.
On what ground?
Lordship, B. Sharma has got some difficulty today, Lordship.
On the ground of personal difficulty of the conducting counsel for the respondent. Learned counsel submits that he has informed the learned counsel for the appellant regarding his prayer for adjournment today, and who has no objection to the said prayer. Considering the submissions made by learned counsel for the respondent, the prayer is allowed. Let this matter be listed after 2 weeks.
Obliged, Lordship.
Lordship, I beg to mention item number 50 of supplementary list.
50. Yes.
Lordship, conducting counsel Ms. S.K. Nargis is unavailable today.
You are seeking adjournment.
Lordship, moreover, the item number 50 is tagged along with item number 51. But item number 50 is part heard, Lordship. I'm unaware how that is tagged
Part heard by which court?
by this honorable court.
Okay, now what is your prayer?
Lordship, I am just unaware how that matter is tagged along with item number
We'll
51.
see when it is called.
Lordship.
You are not praying for adjournment.
Lordship, I am praying for adjournment today. For item number 50.
Why it is tagged with 51? You are not aware.
Yes, sir.
Okay, we'll adjourn it when it is called for.
Yeah.
50 will adjourn it, but
Yeah.
we'll see why it is tagged with
Yes.
51.
May I please, Your Lordship?
Not like it. So
Lordship, I beg to mention item number 42, Lordship. Lordship, the conducting counsel, Mr. Shom, is unwell today, Lordship. Can this matter be taken up any other day, Lordship? I shall inform the petitioner, Lordship. 42.
you have not informed.
No, I tried to contact them, but could not reach them.
No, you have to inform. First you inform, then you can make mention at 2 also,
Lordship.
because it is in
Mr. A.K. Pulkaister is there.
in below the in the
Yes.
last part of the list. You may make mention at 2.
Obliged, Your Lordship.
May I please come also? I beg to mention item number 22 for adjournment because the learned senior, my senior, he was conducting the case and he had to left to New Delhi for his treatment and operation.
You have informed the other
Yes,
side.
yes. I've informed the other side and kindly this matter be taken after means in the second week of September because by that time he will return.
What is your name?
Participating Roy Chaudhary,
Who is
Uh,
indisposed?
Sukumar Sharma. On behalf of
Eh,
Sukumar Sharma.
S. Sharma for respondent. For respondent side.
Yes, from the residence.
Heard Mr.
Parthapatim Roy
Parthapatim
Chaudhary.
Shah. Parthapatim
Roy Chaudhary.
Roy Chaudhary, who is submitting on behalf of Mr. S. Sharma, learned counsel for the respondent. Learned, he submits that Mr. S. Sharma is indisposed and has undergone a operation
Yes.
and is not in a position to attend the court today, and hence prays for an adjournment for 6 weeks. He has also submitted that he has informed the counsel for the petitioner side, and who has conveyed his consent to the prayer made by the respondent counsel. Considering the submissions made by learned counsel for the respondent, the prayer is allowed. Let this case be listed after 6 weeks.
That's nice.
Lordship. On tomorrow, my lord, I have a hearing matter and fixed matter, my lord. The learned counsel for the respondent, my lord, my senior, my lord. And due to his family member is demise, my lord, it will come to the court, my lord.
Make mention tomorrow.
Lordship, no, I have already adjournment slip. I have.
You may give adjournment slip, but make the mention tomorrow.
Lordship.
not today, because today file is not before us.
Item number 1. Motion. May I please, your Lordship. It's 439 application, Lordship, and here is the apparently, Lordship, and contents of the FIR is the petitioner is the land grabber, Lordship. But the and the other co-accused already been arrested in connection with this case, Lordship, and they have already gone bail.
Why it is
And the
this?
petitioner is a Mason, Lordship, by profession.
No, why this case is listed before this court?
I don't know, Lordship.
There must be some reason, because I am not taking
I don't
bail
know, Lordship.
roster.
But it is automatically listed, but Lordship. But even then, Lordship, I have not mentioned also. But earlier, Lordship, and
What
some
is the police case?
Gorsuk police station. 325, Lordship of Gorsuk police station. And Lordship, earlier, Lordship, and one more cases already disposed of by your Lordship.
Connect
And I
with-
have the order.
Of the same case,
Similar,
same,
Lordship. These are the order.
same police station case.
Yes, Lordship.
Perhaps therefore, okay.
Yeah.
Yes, Mr. Where is the rejection? Where is the earlier order? Case diary would be required. When, since when you are behind the bar?
38 days, Lordship, and that was 9/6/2024.
9/6. The same rate of use of precision. Wait.
We'll call for the case diary.
Lordship, and 38 days already.
We will fix a short date. Heard Mr. F. Hawk, learned counsel for the petitioner, also heard Mr. K. Boshaw. K. Boshaw, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the case diary. When? Fixing 24/7 for case diary.
Obliged, Lordship, obliged. Item number 2. And with a regular bail application, my lord, under the new act, my lord, for 483 CRPC. Here, my lord, the petitioner was shown as, my lord, in connection with another case. Your lordship will find the shown as memo page 16, my lord. There are total 5 accused, my lord. And out of the 5 accused, my lord, already the main accused, my lord, the accused number 1, page number 16, my lord, your lordship will find. Already has been analyzed on bail, my lord, by your lordship, my lord, on 28th of June, my lord. And petitioner was, my lord, the earlier, my lord, arrested.
Where is that order?
Lordship,
Where is that my order?
my lord, that bail order, my lord, that BA number, my lord, 1908.
Wait, you have annexed that order?
But I have not annexed, my lord. But the case number, my lord, both the case number disposed of on 28th of June, my lord, by your lordship, my lord.
Since when you are behind the bars?
My lord, since 6th of June, my lord, in Local Shield PS case. Then on 15th of June, my lord, I was shown arrest and I
In
was
this case, 15th of June.
Yes, then I was shown and taken into police remand also, my lord. I was thoroughly interrogated, my lord, and nothing, my lord, nothing increased.
Yes, Mr. Boshaw.
Lordship, the transaction is about the 10 lakhs and he is a FIRM accused.
Yes.
In this.
Heard Mr.
And main accused, my lord, he was, my lord.
No, there is the case diary. Heard Mr. M.A. Islam,
Okay.
learned counsel for the petitioner. Also heard Mr. K. Boshaw, learned additional public
Main
prosecutor.
accused already issued.
Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the case diary. Fixing
24 lakhs.
24/7 for
Short date, my lord, otherwise, my lord.
Then 22nd Lordship.
The main accused.
22nd
26.
7 for case diary.
Item number 3.
22nd.
Shorter date, my lord, before then. It is a Jalugari PS, my lord.
No, PP has suggested the date.
All the
He-
two accused, my lord, have been analyzed on bail, my lord. To your lordship, pass the order, my lord.
What do you want?
My lord, no issue. Always. I wanted the similar order also. No issue.
Wait for 20 seconds.
Lordship. My please, Lordship. So,
It is a charge sheeted
yes,
case.
Lordship. I am behind for 1 year, 7 months, 1 day, Lordship.
What is the stage of trial?
Lordship, that is page 33, Lordship. One of the co-accused has already been enlarged on bail by this honorable court. There were 2 accused persons, out of 3. Those are 3 accused persons total. Out of 3, 2 are already enlarged on bail. Another is allowed on bail by the trial court below. Lordship, since the date of arrest, Lordship, till that, not a single witness has been examined, Lordship. During this 1 year, 7 months, 1 day, Lordship. Not a single witness has been examined, Lordship. Order.
Yes, Mr. Sorry.
Lordship, 20C and 29 of NDPS.
No.
Page 33, Lordship.
But co-accused are granted bail on.
Lordship.
Lordship, in this case, Lordship is because the matter relates to maybe LCR may be required, Lordship.
Lordship, the petitioners were arrested on the same day, under same
We
day.
will call for a status report.
Lordship.
You are saying that not a single witness.
I have the latest last recent order, that order was on 8/7. 8/7, Lordship, the order reads as follows. Last order was, Lordship, 8/7.
You have not annexed that order.
Lordship,
You have not annexed that order.
I have not in it. It is,
We'll fix a short date. We are not calling for scan copy of the case record.
Lordship,
We will call for a status report of the trial,
Lordship,
fixing a short date.
Lordship.
Now, Mr. This is item number. P.K. Saharia, learned counsel for the petitioner. This application under section 483 of the BNSS, 2023 has been filed by the petitioner Maidi Doimari, who has been detained behind the bars since 18/12/2022 within
Yes,
bracket for last 1 year, 7 months, 21 days.
1 day.
21 days
1 year, 7 months, 1 day.
since for more than last 1 year, 7 months, bracket close. Learned counsel for the petitioner has submitted that though the petitioner has been detained behind the bars for last 1 year, 7 months, however, till date, not even a single witness has been examined by the trial court. So, in view of the submissions made by learned counsel for the petitioner, let a status report of the trial in NDPS case number 74/2023 pending before the Court of Learned Additional Sessions Judge number 3, Kamrup Metro Guwahati, be called for registry to issue requisition for the status report. Let this case be listed again on 24/7.
24/7.
24/7.
Item number 4. Petition.
6 and 7.
For 6.
Yes, what is the matter?
My pleasure, Lordship. Well, Lord, this revision application has been filed by the petitioners for setting aside and quashing the impugned order dated 29/2/2020, passed by the learned civil judge number 1 in Mizze case number 46 of 2020.
Whether all parties have appeared?
Yes, my lord.
All
I am for
respond.
6 and 7.
I am
6
for
and 7.
1.
You are for.
Respondent 1, Lordship.
And as regards other respondents, whether service is complete?
Service is complete, Lordship.
Okay. Okay. Where is the impugned order?
My Lord.
Page?
Impugned order, Lordship, is at page 37. passed in Miss J case number 46
No,
of
what should
22.
we do? Should we admit it and fix it for hearing, or should we hear it?
My lord, in that case, what has happened is because there was a delay on the part of the petitioners in taking steps in this revision petition. So Honorable Justice D. Borua directed that the proceedings in the title suit also should commence, should proceed with. Now, my lord, my submission is, since
So
this
trial court proceeding is going on.
is going on because there were some lapses on the part of the petitioners in taking proper steps at that point of time. So the interim stay was vacated and order was passed that the proceedings should continue. My submission, Lordship, is since the matter relates to, I mean, joinder or striking of parties. So if your Lordship is pleased enough to stay further proceedings, then let the matter be fixed for
No,
hearing.
once court has
But then, my lord,
vacated the stay, if ultimately it is found that who is, according to you, is not required to be impleaded as party, 6 and 7.
6 and 7, Lordship, in fact, the
No,
learned trial
suppose
court,
6 and 7 are not found to be proper or necessary party.
my lord.
They may be strike out at any stage of the trial, later on also.
But then in that situation, Lordship, the trial will proceed, maybe there will be
We
a
will
change
give
of.
a fixed date. We'll admit it. No, what do you suggest?
Lordship, this order is an erroneous order, prima facie erroneous, because the learned trial court got it wrong, because this was an application which the petitioners had
I'm not-
objected to.
I just want to know whether we can dispose it off at the admission stage,
Yes, my
or
lord.
what is your suggestion?
Be disposed of in the admission.
Today itself, today itself.
Please submit thereafter also.
Okay.
So Lordship, kindly
Make your submission.
come to the impugned order.
Yes. This is a suit for,
This is a suit for declaration, confirmation of possession, and permanent injunction by the petitioner.
you are in possession of this.
Yes, yes, my lord. Since 1983, the land was purchased by the company. We are in possession. Now, somehow, because of some developments in the year 2016,
Why have you filed this suit?
because Lordship, the respondent number 1 and some of the other legal heirs who claim to be the descendants of the seller from whom we had purchased the land way back in 1983, which was not challenged at all, my lord. So there was some proceeding by a person who claimed to be the son of the purchaser of the seller in the year 2007, 2008. That was compromised between the parties, and there was no issue at all. And then, Lordship, this
No,
respondent number 1.
Where
in
is the, how much is the suit length? Where is the suit length?
Yes.
It's 7.
From whom you have purchased?
I'm coming to it, Lordship.
It's 7.
Yes.
No, therefore I was suggesting if you are not ready, we will fix it for hearing.
No,
Come.
Lordship, the issue here is,
No, but what is the suit length? Where it is situated? When have you purchased it? From whom you have
Yes.
purchased it?
suit line, my plaint is annexed. Lordship, kindly come to page 13.
Yes.
Annexure 1, which starts at page 12. Annexure at that page 13, Lordship. Paragraph, internal page number 2, paragraph 3. That the plaintiff number 2 purchased a
2 bighas land.
yes,
From whom you have purchased?
measuring about so and so. From the possessor and recorded Pottadar late Tatari Lalungani, wife of late Shyam Singh, white deed of sale number so and so of 83 dated 2/7/1983. And since then,
This
Lordship,
was registered sale deed.
yes, yes.
Thereafter, your name has been mutated in
Yes,
records
yes,
of
that
right.
was- names were also mutated.
Thereafter, what happened?
We also have been in possession
When
since.
you are in possession of these 2 bighas land,
Yes, yes.
then
Then Lordship, the whole story will unfold if Lordship comes to paragraph 4 of the same page, down below, page 13.
yes,
That the plaintiff states that the father of the defendant, late Golendro Momin, during his lifetime preferred miss case number 71 of 0607 before the settlement officer under section 151 of the Assam Land and Revenue Regulation, inter alia, praying therein for cancelling the mutation granted in favor of the plaintiff number 1. The petitioner in the said case, Golendro Momin, claimed to be the legal heir of Tartari Lalungani. The settlement officer, wide order dated
who
27/9/2007.
is Golendro Momin? Respondent number 1.
I'm meeting.
Golendro Momin is respondent number
No,
1.
Lordship. That is when the father of this respondent number 1, he initiated a proceeding in 2007. There was a compromise between the parties.
Okay.
Thereafter, he passed away. Now in 2015, the respondent number 1, claiming to be the
Heir-
daughter.
Okay, daughter of Golendro Momin.
Yes, daughter of, now she comes into the picture and says, and files the fresh round of litigation against the petitioners.
No, she has not filed the suit. Suit has been filed.
We filed because the reason is because she filed a petition before the settlement, before the circle officer, concerned circle officer, challenging the mutation of our names in the revenue records.
Okay.
Now, there was a connected revenue appeal pending, Lordship. So at the same time, we preferred the suit.
Where? Board of Revenue.
No, initially it was before the ADC, which was dismissed. Then the matter went up to the Board of Revenue. The Board of Revenue also dismissed the appeal preferred by this respondent number 1. Now these are subsequent developments, Lordship. But when the respondent number 1 preferred the complaint before the circle officer, that is when in 2016 we filed the suit praying for declaration of right title and interest and confirmation of possession. Now, thereafter, my lord, so far the respondent numbers 1 to 5 are concerned, that's all right. The issue lies with the impleadment of the respondent numbers 6 and 7.
What are their names?
Yes. 6, Lordship, is 1 Haider Ali and 7 Abdul Noor. Now kindly come to the petition filed by
Haider Ali and Abdul Noor.
Lordship.
Haider Ali and
Abdul Noor. Yes, my lord.
Where is the
Respondent
imp-
number 6 and
Now,
7.
where is the impugned order? 30,
Yes.
Page 37.
Page 37. This is a petition filed by them for impleading them as party defendants. Now see the error in the order. The learned trial court has proceeded to pass the order as if the petitioners had filed the petition. May I read it?
Yes.
This miscase arose out of a petition number 4697 filed under Order 1, Rule 10, Sub-Rule 2 of CPC, wherein the petitioner prayed to implead them as defendant number 4 and 3. The petitioner in the instant petition submitted that late Golendro Momin had left 5 numbers of legal heirs and successors, namely so-and-so, so-and-so, so-and-so. So he prayed to implead them as party to the suit. He has got it all wrong, my lord. This is not the case at all. No mention of the 2 applicants.
Yes.
Now-
Where are their names?
No name, even names are not.
Then how they can be impleted?
No, that is it. That is the order. That is how they have been impleted, because this is,
On the basis of this order,
yes.
where is the impleadment order?
No, this is the order.
But
Correct.
their names are not there.
9 names are not there.
Then
Names are not there, but the miscase 46 of 2022 is the application filed by them, which I have annexed, lordship, at page 21 to 24. This is the application filed by these two, the respondent numbers 6 and 7.
At which page?
Lordship, page, it starts from page 21, annexure 2.
This was filed by the two petitioners. Either.
Annexure 2, page 21. Application under Order 1, Rule 10, Sub-Rule 2 of CPC. These are the two petitioners, Haider Ali and Abdul Noor. And their ground for being impleaded as party respondents is that they have some agreement with the
No,
defendants.
but the order speaks that it is the plaintiff who
Yes,
has
that
to-
is that is why I'm before this court, Lordship. This is the error on the part of the learned trial court. This
You-
is This is
have you
not my
filed any
petition.
objection against?
Yes, I filed my objection.
Where is your objection?
My objection starts from page 25, annexure 3. Kindly come to page 25, annexure 3. This is,
You have objected to their impleadment.
yes, my lord, I have objected. We have objected.
On what ground?
Lordship, the grounds,
What was the ground for their seeking of impleadment?
their ground for seeking impleadment is that they had executed some agreement with the respondent numbers 1 to 5. And on that basis, they claim to be
Who
necessary
agreement
parties.
for sale of that plot of land?
No, Lordship, no agreement was in fact enclosed with their application. And that is a specific ground that we had taken in our objection. If Lordship kindly comes to page 28, kindly come to page 28. This is my objection, the relevant portion. Page 28, paragraph 5. Has Lordship got it?
Yes.
May I read it? That the plaintiffs beg to state that the petitioners has preferred an application under Order 1, Rule 10, Sub-Rule 2 of CPC for being impleaded in the suit on the basis of deeds of agreements of sale for sale, white number 6171 of 17 dated 24/6/17 and deed of agreement number 6172 of 17 dated 24/6/17. Purportedly executed by some of the legal heirs of late Golendra Momin, that is Srimati Labainu Sangma and Sri Elbinston Sangma with the petitioners. That is Haider Ali and Abdul Noor, the copy of which had not been furnished with the application. That is a categorical ground we have taken. Those documents were not even enclosed with the application before the trial court. So next, kindly come to paragraph 6, Lordship. That the plaintiffs beg to state that the suit is between the plaintiffs and the legal heirs of late Tatari Lalangani, that is the defendants, and the petitioners are no way connected with the issues raised in the suit. If the petitioners have any right or claim on the straight of the said agreements dated 24/6/2017, the same is against the defendants and not against the plaintiffs. As such, they cannot claim for impleadment in the suit under Order 1, Rule 10, Sub-Rule 2, as they are not necessary and proper parties in the suit. Therefore, the petitioners has no locus standi to prefer this application for impleadment in the suit pertaining to the scheduled land. Firstly, Lordship, they file an application and they don't even enclose the copy of the so-called agreements. Those are not there. And the second thing is, since it's a suit between the purchasers and the so-called legal heirs of the original seller, what is their locus standi to be impleaded as party defendants? So these are the grounds on which we objected to the petition.
And what is that page 38?
Page 38, Lordship, what happened was at the same time, we also preferred an application for impleading some more defendants who happen to be the legal heirs of the
That is on the
seller.
basis of your application.
On the basis of our application, and we have no objection. These defendants were rightly impleaded and they are here before this court also, represented by my learned friend. But the issue is pertaining to respondent number 6 and 7. Firstly, they file an application with which no document is submitted before the trial court. That is one objection. Second objection, Lordship, is what right have you got to stand in between the plaintiffs and the defendants? If there is any right, there is any right accrues to you, that only pertains to the defendants, that is the respondents in the here before this court. But somehow the learned trial court, I don't know, maybe got it all wrong and passed the impugned order in the manner in which it has done.
Okay. Yes. You are for
respondent number 1, Lordship.
Golendra Momin.
Yes, it is.
No, who is respondent number 1?
Zenitha Sangma, Lordship.
With whom the 6 and 7 have an agreement.
He is agreement, 6 and 7.
With you, they have an agreement to sell.
No, Lordship.
You don't.
We have not made any agreement with the 6 and 7, Lordship.
But they claim.
Even Lordship, 6 and 7 never enclose any documents regarding their claim, Lordship.
What is your name?
SN Odhyapak.
No. The
Zenitha Sangma, Lordship.
Jenitha.
Zenitha Sangma, respondent number 1 in this petition, Lordship.
And you are defendant number?
Defendant number 1, Lordship.
Defendant number 1.
1. And regarding other respondents, they have not received any notice, Lordship.
Okay. What is your submission?
Lordship, they have not made any agreement with the respondent number 6 and 7. And regarding their claim, Lordship, they have not submitted any documents in the trial court. On which basis they claim that they are a necessary party in the suit.
Okay. Yes.
May I please, Your Lordship? Lordship, record reveals that there are 2 applications for impleadment. One application Lordship will find as annexure 2 at page number 21.
Which was filed by you.
Yes, by the respondent number 6 and 7. And in connection with this application, the plaintiff side has also filed their objection, which is annexure 3.
Okay. They have
That Lordship will find from page 25 onwards. Thereafter, Lordship, there is another impleadment application which was filed by the plaintiff for impleadment of Srimati Laibanu Sangma, Srimati Sukila Sangma, and Srimati Brepila Sangma as party defendant number 3, 4, and 5 respectively in the aforesaid suit. And both these 2 applications, now my lord, the problem here is very much simple. The problem arises due to copy paste. While passing the order.
So it has to go. Then order would.
Yes, Your
not a
Now the
sustainable
problem
order.
is regarding what he has said or my learned friend has said. In my application for impleadment, I have categorically stated in para 4 of my application that Lordship will find it page number 22. Para 4, my lord.
Yes.
Page number 22. That all the other legal heirs and successors of late Golendra Momin have told the petitioners that they also deny the fact that the suit plan of the suit has been sold to the plaintiff. The said legal heirs and successors have also denied about any arrangement. Agreement dated 18/2/2009 entered into between the plaintiff number 1 and late Golendra Momin. In fact, the said legal heirs and successors have also claimed title over the suit land, and on the basis of said title, 2 of the legal heirs of late Golendra Momin, namely Laibanu Sangma and Ella Biston Sangma have entered into 2 agreements for sale with the petitioners bearing deed number 6171/17 dated 24/6/17 and deed number 6172/17 dated 24/6/17 for sale of a part of the suit land measuring 4 kotha in total. So on the basis of these 2 registered agreements, although we have not filed, but it is a matter of record that there are existence of 2 registered agreements, Your Honor. So
Then-
there is now, as per the scheme of
then
order
you-
1, rule 10 to my lord.
Then you may have grievance against Libano and Elbinston. What grievance do you have against the?
Because now out of this entire suit land, this 4 kotha is a part of the entire suit land. And my lord, what actually happened? Now, if your lordship peruse the order dated 29 to 2020 and also the 29 to 2020, both the orders passed on the same day. One order is passed on our application and one order is passed on the application that is filed by the plaintiff side. But here, what happens? So, in the 37, page number 37, Miss case 46/2020, I think you're challenged this order.
Yes.
46. So 46/2020, this order is challenged, passing Miss J case. So now, court is under the impression that this application is also filed by the plaintiff. And accordingly, whatever plaintiff has spread in their in his application, in the impugn order, the name of those parties are mentioned. And accordingly, it is said that consider the submission of the petitioner. I am of the view that the plaintiff is the best person who knows about the merit, demerit of this case, and he is the master of his plaint, and he has the right to sue the party. In view of the above background, when the plaintiff has shown sufficient cause why he wants to implead the above parties, I deem it fit to allow the petition, hence petition is allowed. So bench assistant will do the needful entry in the plaint. Accordingly, my lord,
Your
in the
name
plaint
was
also, our names are now entered, included. As lordship, I have a certified copy.
No, but apparently the order is wrong order.
Yes, my lord, from this point of view, copy paste. So kindly, my lord, matter may be remand and let our application may be heard and a proper order may be passed. Because actually the 6 and 7 are implemented by this order, but their names are also not reflected. The names of the other defendants which the plaintiff raised, their names are reflected in the order. In fact, in both the orders, it is not said actually who is going to be implemented or who is implemented. So let the matter may be remanded. My humble prayer at this stage.
But
No.
to a point, my lord is.
Copy paste, my lord.
My
Problem
submission,
arises due to
lordship,
copy
firstly, the order is erroneous. And secondly, lordship, as admitted by the counsel for the respondent number 6 and 7, you file an application for being impleaded on the strength of some document which you have not even submitted before the court. Does the submission hold any ground, my lord?
Okay, heard,
My lord,
yes.
see,
You
regard
don't
to this
submit,
submission,
you don't
there is
submit
no such
documents
scheme
and you
under
say-
order 1 rule 10(2) that when that application has to be filed, some other documents has also to be relied. Because as we are now implemented as defendant now,
How court would assess that you are proper
Yes,
party
lordship,
yes,
unless materials are before
materials
that
are
court?
not there,
no,
my
my
lord.
lord.
There was
The-
no material
The
apart
point is,
from.
my lord, we have referred to the deed numbers. Now, when we will get the opportunity to file written statements, definitely we will file the
When,
documents, my lord.
hearing on the application took place.
With pleadings, documents will go.
Okay, I have understood your submissions.
This has to go, my lord. It is erroneous.
Mr. A. Sharma, you are A. Sharma.
A. Sharma.
A. Sharma, learned counsel for the petitioner. Also heard Mr. S. Day. S.N. Adhyapak, learned counsel.
My lord, I am B. Bora, but my name is not reflected in the cause list
Learned counsel for
for 6 and 7.
respondent number 1. And also heard Mr. B. Bora, learned counsel for respondent number 6 and 7. This revision petition has been filed under Article 227 of the Constitution of India by the petitioners, Messrs. Eastern Road Carriers, Number two, Messrs. Eastern Road and Shri Ravi Kumar Mittal. Who is Ravi Kumar Mittal?
He is one of the partners of the managing partner of
Who
the
is one of the
petitioner number.
managing partner of the petitioner number one, impugning the order dated 29/2/2020, passed by learned civil judge number one, Kamrup Metro in Miss J case number 46/2020, arising out of title suit number 322/2016, pending before the court of learned civil judge number one, Kamrup Metro. The facts relevant for consideration of the instant revision petition, in brief, are that the petitioners have claimed to have purchased a plot of land measuring 4 bighas. Where is that description of the land?
Lordship, it is page 3 of my petition, Lordship. Lordship will get it, paragraph 2.
Two bighas land.
Yes.
Purchased 2 bighas of land covered by KP Patta number 92, Dag number 416 in village Betkusi under Moja Beltola police station Dispur, from the recorded Patadar and possessor of the said land, late Tartari Lalungani, wife of late Shyam Singh, by executing a registered sale deed number 5015/1983, dated 2/7/1983. It is contended by the petitioner that later on one of the legal heir of the seller of the said land, namely Galendra Momin, raised some objections regarding the purchase of land by the petitioners. However, the matter was amicably settled between the said Galendra Momin and the petitioners, and a deed of agreement was executed on 18/2/2009 and 18/2/2009. Stop. Who filed this 89 title suit 89/2008? It is pertinent to mention here in the
Yes, title suit at that point of time was filed by these petitioners only.
you have filed.
We had filed, and these were all
How-
compromised between the
Okay.
predecessor of the present
In-
defendants.
It is pertinent to mention here in that in the meanwhile, the petitioners had filed a suit against said Golendro Momin before the court of learned Munsif number 1 Guwahati, which was registered as title suit number 89/2008. And said suit was decreed on compromise on 18/2/2009 on the basis of the deed of agreement. No. Decreed on compromise on 22/4/2010 on the basis of deed of compromise, which was entered into between the parties on 18/2/2009. Stop. Later on, some of the legal heirs of said Galendra Momin again raised some dispute over the title of the land purchased by the petitioners, and they filed applications for cancellation of mutation, which was in the name of the present petitioners. Stop. Thereafter, the present petitioners filed a title suit before the Court of Learned Civil Judge number 1, Kamrup Metro, praying for declaration of right title and interest over the scheduled land, which was the land purchased by the present petitioners from the predecessors of Galendra Momil. The said suit was registered as title suit number 322/2016 and is presently pending before the Court of Learned Civil Judge number 1, Kamrup Metro. Stop. Learned counsel for the petitioner has submitted that in the meanwhile, the respondent number 6, learned counsel for the petitioner has submitted that the petitioners had filed an application before the trial court under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure for impleading two legal heirs of the seller of the suit land, namely Srimati Laibano Sangma and Srimati Sukila. Three legal heirs, Laibano Sangma, Srimati Sukila Sangma, and Srimati Brepila Sangma. And said prayer was allowed by the Learned Trial Court by its order dated 29/2/2020. And the three respondents, three legal heirs named by the present petitioners were allowed to be impleaded as defendants in the suit filed by the plaintiff. Stop. However, in the meanwhile, on the same date, respondent number 6 and 7, namely Haider Ali and Abdul Noor, also filed an application under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure, praying for impleading them as defendants in the suit filed by the petitioners on the ground that the two of the legal heirs of the original owner of the suit land, namely from whom you have purchased, namely Laibano Sangma and Ella Binston Sangma, had entered two agreement for sale with the respondent numbers 6 and 7, bearing deed number 6171/17 dated 24/6/2017 and deed number 6172/17 17 dated 24/6/2017 for sale of 4 kathas of land out of the suit land and claim that they also got interest in the suit land to the extent of 4 kathas. Stop. Learned counsel for the petitioner has submitted that though the respondent number 6 and 7 were totally stranger to the suit and were not connected anywhere in the dispute between the petitioner and the other petitioners and the other defendants of the said suit. Their names, the names of respondent number 6 and 7, namely Haider Ali and Abdul Noor, were impleaded in the plaint on the basis of impugned order dated 29/2/2020, passed by learned Civil Judge number 1, Kamrup Metro, in Miss Case number 46/2020. Stop. Learned counsel for the petitioner has submitted that bare perusal of the impugned order would show that though that the names of the respondent number 6 and 7 are not reflected anywhere in the said order. However, on the basis of the said order, their names were impleaded in the plaint by the office of the court of learned Civil Judge number 1. Learned counsel for the appellant, learned counsel for the petitioner has also submitted that the petitioners as plaintiff have filed the suit against the heirs of the original seller of the land, as the heirs of the original sellers of the land have preferred an application for cancellation of mutations, cancellation of mutation order in favor of the petitioners in respect of the aforesaid land. Learned counsel for the petitioners has submitted that the petitioners have no dispute with the respondent number 6 and 7, and they are not either necessary parties or proper parties for resolution of dispute between the petitioners and the other respondents in the pending civil suit. Learned counsel for the petitioner has also submitted, though the respondent number 6 and 7 have claimed to have entered into an agreement for sale with 2 of the heirs of the original seller, namely Laibano Sangma and Ella Binston Sangma. However, no copy of the purported sale deed have been furnished or annexed along with their impleadment petition. And therefore, the court, without application of mine, allowed the miss case number 46/2020, which was filed on the basis of application filed by the respondent number 6 and 7 under Order 1, Rule 10(2) of the Code of Civil Procedure. Learned counsel for the petitioner has submitted that for the grounds taken by the petitioner, the impugn order is liable to be set aside. On the other hand, Mr. S. N. Adhyapak, learned counsel for respondent number 1, who is respondent number 1?
Zenitha Sangma.
Zenitha Sangma, who is the daughter of the daughter of late Golendra Momin, with whom petitioners have entered into a compromise earlier, had never entered into any agreement with the respondent number 6 and 7. You have no objection if the prayer is allowed. If the prayer of the petitioner is allowed. And submits that he has no objection if the revision petition is allowed. On the other hand, Mr. B. Bora, learned counsel for respondent number 6 and 7, has fairly submitted that bare perusal of the impugn order would show that there is some error in the said order, as it appears to have a result of copy and paste, as on the same date the petitioners had also filed an application for impleadment of 3 of the legal heirs of Golendra Momin, and which was allowed by the trial court. And it appears that same order has been pasted while considering the application filed by the respondent number 6 and 7, which has resulted into an erroneous order. However, learned counsel for the respondent number 6 and 7 has prayed that in view of the error apparent on bare perusal of the impugn order, he prays for remanding the case back to the learned trial court with a direction for considering the application filed by the respondent number 6 and 7 afresh by the learned trial court. I have considered the submissions made by learned counsel for the parties and have perused the materials available on record. For the sake of convenience, the impugn order, for the sake of convenience, the order of the trial court dated 29 2020 passed in Miss Case number 46/2020 in connection with title suit number 322/2016, which has been impugned in this instant revision petition, is quoted herein below. Impugn order, page 37. Quote correct. No. Only page 37. A bare perusal of the order would show that there is no mention about the names of respondent number 6 and 7 in the said order. It also appears that the trial court in the said order has allowed the petition filed by the respondent number 6 and 7 on the ground that the plaintiff, within bracket the present petitioners, do not have any objection to said impleadment, comma, which is not the case, as the petitioners had objected to the impleadment of respondent number 6 and 7 by filing a written objection before the trial court, which is annexed along with this revision petition as annexation number 3. It also appears that it has also been admitted by learned counsel for the petition, learned counsel for respondent number 6 and 7 that the respondent number 6 and 7 had not annexed or produced the copies of the agreement for sale, which is purported to be entered into by respondent number 6 and 7 with 2 of the legal heirs of the original seller of the land. Therefore, comma, it appears that the trial court, it appears that no materials were before the court for consideration, on the basis of which the prayer of respondent number 6 and 7 was allowed by the trial court, apart from the impleadment petition filed by the said respondent. Moreover, it also appears that as apparently the impugn order is erroneous to the extent that it mentions that plaintiff has no objection to the said impleadment order, whereas in fact the plaintiffs, within bracket, that is the present petitioners, had objected to such impleadment. As the plaintiff is the dominus litis in a case and it has right to choose the defendants, and as it appears that, as from the materials on record, it appears that the suit preferred by the plaintiff the suit, that is the title suit number 322/2016, was preferred by the petitioners as plaintiff seeking redressal against the grievance against only the legal heirs of Galendra Momin. Your grievance is only against legal heirs of Galendra Momin and nobody else. Hence, stop. For aforesaid reasons, it appears that there is total non-application of mine by the trial court in passing the impugned order dated 29/2/2020, and therefore same is not sustainable. For the reasons stated above, the impugned order dated 29/2/2020 passed in Miss Case number 46/2020 in connection with title suit number 322/2016 is hereby set aside. The names of the respondent number 6 and 7, which were impleaded on the basis of the impugned order, shall be strike out from the plaint in title suit number 46/2020. This criminal revision is accordingly, this civil revision is accordingly allowed and dispensed.
Item number 5.
None appears for the appellant on call. Despite the names of the appellant have been shown in the cause list. On perusal of the record of the case, it appears that on last 2 occasions also, the appellants were unrepresented and none have appeared on call. In view of above, this appeal is dismissed for non-prosecution. Dismissed for default.
Item number 6.
Yes.
Not your lordship. This is against the order dated 5/3/2018 passed by the Senate MS member, your lordship. In this case, your lordship, future prospect was not calculated here. As per the guidelines of the Supreme Court.
You are the insurance company, or
Your lordship,
it is for enhancement?
yes, your lordship.
Enhancement. Heard, Mr. What is your name?
That's right.
Heard, Mr. S. Roy, learned counsel for the appellant. This is an appeal under section 173 of the Motor Vehicles Act, 1988, filed by the claimant's appellant against the praying for enhancement of the compensation awarded to the appellants in MEC case number 26/2016 on the ground that the London Motor Accident Claims Tribunal have granted inadequate compensation to the appellants without considering the guidelines issued by the Apex Court in the case of National Insurance Company Limited versus Pranay Sethi and others, reported in 2017-16 SCC 680. Issue notice to the respondents and call for the
In this case, Your Lordship,
the
insurance company already appeared in this case, Your Lordship.
where are they?
Their name have been shown in this case. So I will,
No, but no notice was issued.
not issue.
Name has been shown, but they are not present today. Have you served notice on them?
I will serve Your Lordship. I will inform
Then
them.
you have to take steps.
Okay.
Issue notice to the respondent and call for the case record of MEC case number 28/2016 from the Motor Claims Tribunal, Karimganj, the registry to take steps for requisitioning the case record. The petitioners shall take, the appellant shall take steps for issuance of notice which returnable after 4 weeks. Let this matter be listed after 4 weeks.
Item number 7.
Lordship, this appeal is filed by the claimant from Quantum against the impugned judgment and award passed by the learned MSCT 2 on 22 April 2020.
Filed by the claimants,
Yes, Lordship.
the case was dismissed or it is for enhancement? Enhancement. Heard, Miss, what is your name?
C. Agarwal.
C. Agarwal, learned counsel for the appellant. This appeal has been filed under section 173 of the Motor Vehicles Act 1988 by the claimants praying for enhancement of the award granted to the appellants by judgment and award dated 22/4/2024, passed in MAC case number 1128/2014 by by Motor Accident Claims Tribunal number 2, Kamrup Metro. Issue notice to the respondents and call for the case record of MAC case number 1128/2014 from the concerned tribunal. The appellant shall take steps for issuance of notice to the respondents within 3 days from the date of this order, returnable after 4 weeks. Registry to take steps for requisitioning the case record from the concerned tribunal. List this matter after 4 weeks.
Item number 8.
Lordship, my may claim indulgence, Lordship. In the other matter, item number 6, Lordship, and for respond number 2. Item number 6, Lordship. My learned friend has appeared.
Item number 6.
Yes,
Lordship.
Your Lordship. In this case, that earlier case, Your Lordship.
Notice was not served upon respond number 1.
Yes, I will serve this copy.
I am appeared, Lordship.
Item number 6 of Likho. As Miss
M. Chaudhary.
M. Chaudhary has appeared for respondent
Number
number 2.
two.
No formal notice is required to be sent to respondent number 2. The petitioner, the
Yes,
appellant
Lordship.
shall
I'm going to submit, Your Lordship. In this case, in regard to the respondent number 1, Your Lordship, where in IA case, in delay petition case, we have already served notice to paper publication. After that, they have not appeared, Your Lordship.
That is
But
in
here,
that case,
here,
Lordship.
here
That is in
also you
IA
have to
only.
take. That is only regard to.
Yes,
condemnation. Here you have to take fresh steps. They will take steps only with regard to Respondent number one.
Must oblige, Lordship.
Item 8.
Legal Lordship. After this application file, it was ground that the policy did not cover the pillar man. It was
Your
an act
insurance
policy,
company. Insurance company.
insurance company. In this case, the insurance company had also adduced evidence to say that this is a 5-year policy. A new concept has been introduced, a 5-year policy. In the 5 years, it's called bundle policy.
Not
but-
a comprehensive policy.
Lordship,
It was not a comprehensive policy or package policy.
I didn't.
Policy was only act only policy under
Act only policy. At
147.
the time when the accident occurred, it was an act.
The pillion rider was not covered.
Covered. It's covered in a comprehensive policy, package policy, but in the act policy, it is not. And evidence was also given by the insurance company to that effect.
You have deposited statutory deposit.
Yes.
Statutory deposit.
I paid this.
Okay. Third, Mr. R. Goswami.
Yes, yes, August.
Third, Mr. R. Goswami. Learned counsel for the appellant. This appeal under section 173 of the MV Act, 1988 has been referred by the insurance company, namely ICI Lombard General Insurance Company, impugning the judgment and award dated 4/4/2024, passed by learned member MACT number 2, Kamrup Metro, in MAC case number 2062/2022, whereby the learned tribunal has awarded
19,11,026.
awarded an amount of 19 lakhs
11,026.
026 in favor of the respondents. Learned counsel for the appellant has submitted that the concerned tribunal, while allowing the MAC case and awarding the compensation in favor of the respondent, have ignored the fact that the insurance policy in question was only, within inverted comma, act only policy, and the pillion rider was not covered under the said insurance policy. Stop. Issue notice to the respondents and call for the case records of MAC case number 2062/2022 from the concerned tribunal. The petitioner shall take steps for issuance of notice by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. This matter after 4 weeks.
No, sir, instead of registered post, can I take steps to dust it to be faster?
The petitioner may also take steps additionally through dusting.
Not additional lots. In lieu of. If it is possible, in lieu of, I'll take.
No, you take in addition to registered posts. In addition to,
I'll send only registered post.
Okay.
That's why I'll come to the next stage in that case. If no one is found,
Okay.
the next is I'll send it, take it.
okay, list accordingly.
Only. The petition for stay laws.
They will consider after their appearance,
After,
after due
Yes.
service of
In
notice.
the interim, lordship, till they come to the court.
They have filed any execution. Now execution petition may be filed.
They may, lordship, but
They-
just to avoid that kind of a.
Then let us wait till. Then you take steps for. We are issuing notice. This application under Order 41 Rule 5 of the Code of Civil Procedure, 1908 has been filed by the applicant insurance company praying for stay of operation of impugned judgment and award dated 4/4/2024 passed by learned MACT number 2 Kamrup Metro in MAC case number 2062/2022. Issue notice to the respondents. We'll consider it after. Now we are issue notice to the respondent. Here you can take dusty mode if it is urgent.
Yes, lordship, it can be done here. Yes.
The petitioner shall take steps for service of notice on the respondents through dusty mode. And thereafter file an affidavit of to show that the notice have been served on the respondents through dusty mode. The notice are returnable after 4 weeks. Let this case be listed after 4 weeks.
Deeply obliged.
Item number 49 from supplementary list. His lordship.
49 from Appellate.
Okay, application under section 82 of the Employee State Insurance Act.
Yes, yes.
This is an application under section 82 of the Employee State Insurance Act, my lord, against the judgment of the EI court, my lord. And my lord, before the the grounds, my lord, I have stated in paragraph 2, my lord. But that will be admitted, my lord, they have been called for.
It is under section what?
82 of the Employee State Insurance.
Sudeep, into some. What it provides for? Employee State Insurance Act. Read out that.
I have the act, my lord.
Which is the impugned order?
My lord, judgment and order dated.
Okay.
Well, page 5, my lord.
I'm taking a short break.
My lord.
Of 1. '82 of the Employees State Insurance Act 1948, impugning the
Judgment
judgment and
dated.
order dated 12/8/2016, passed by Learned Employees Insurance Court, Guwahati in ESI case number 11/2014. Issue notice to the respondents and call for the case record of ESI case number 11/2014 from the Learned Employees Insurance Court, Guwahati. The appeal is admitted for hearing. The appellant shall take steps for issuance of notice to the respondents by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. The registry shall take steps for requisitioning the trial court record list accordingly. Yes,
Please, today's call for records. Who witnesses the next
whether status report has arrived.
My crown is length of detention, my lord, and already co-accused is released on bail. My lord.
Where is the order?
Order annex 4, my lord, page number 82.
Yes, Mr. Bush. Oh, NCB, where is NCB? NCB has to be there.
Please, let us.
We'll take it after some time. You inform the NCB council.
Item number 50. With 51 from supplementary
Normally. 50-51 cumulative.
So item 50, that was part heard, and early in the morning that was mentioned, Lordship.
Huh?
Lordship, early in the morning, one of our learned friend has already mentioned regarding the item number 50, which was part heard, Lordship.
Yes, yes.
As because learned counsel, Ms. Nargis was
And
not aware.
51?
51, one of our learned friend has already asked me, and he was coming to inform, but not yet. He said that it is from the same FIR, so it is tagged.
50, learned counsel for the petitioner in 50 has prayed for an adjournment on the ground that the conducting counsel on the ground of personal difficulty of conducting counsel Ms. S.K. Nargis. The prayer is allowed. Let this case be listed after a week.
Otherwise, Lordship CD we have received.
Okay, when should we fix?
Lordship, any date, Lordship, then we have to retain the CD.
Let this case be listed again on 24/7. 24/7, the case diary shall be retained till next date. 51 number.
51, item number 51.
No one appears for the petitioner on call. Let this case be listed again on 24/7 for case diary.
No,
For
same case, Lordship.
24/7
24.
and along with bail application number 1735/24. The case diary shall be retained till next day.
24/7 to date this.
Or you are there. 50 instead of no one appears. Heard Mr. N.J. Dutta, learned counsel for the petition. On 24/7.
I'm appearing on 51.
50.
In 51.
It was the same. CD to Ahidus.
I'm okay.
Item number 10. My lord, in this case, when the CD was called for and interim bail was granted.
CD is there.
Yes, no, CD received.
You have
Lordship,
appeared
and his
before.
statement is also recorded.
You have appeared before the.
Yes.
What is your name?
Anisur Rahman.
Heard
Not name, my
Mr.
lord.
A. Rahman, learned counsel for the petitioner.
My name is A. Ali Mani, sorry.
Heard Mr. A. Ali, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner, namely Anisur Rahman, was allowed to go on interim bail by this court with certain conditions on 13/5/2024 and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, an additional public prosecutor has produced the case diary of Nagaon PS case number 231/24 and has submitted that the petitioner has appeared before the investigating officer
On 16/5/2020.
on 16/5/2024 and his statement under section 161 of the Code of Criminal Procedure has also been recorded.
Yes.
In view of the fact that the petitioner has cooperated with the investigation, with the investigating officer in pursuant to the directions of this court, the interim bail granted to the above named petitioner by order dated 13/5/2024 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of.
Item number 11. Maybe. And 438 application, my city was called for. In this case, my lord, there are 4 accused persons, my lord, and 3 were granted period bail by your lordship, my lord. FR page 13, my lord. In this case, my lord, all these sections are bailable except 354, my lord. Page 13, lordship. FIR, page 13, lordship.
What is your name?
Bulal Sheikh.
You are the main accused.
Yes. My lord, one thing, my lord, his lordship kindly see the FIR first. my lord.
Yes.
বিশেষ সন্মান নিবেদন এই যে যোৱা 10 দিন মান ধৰি ভুৰাঘাটা গাঁৱৰ মোৰ নানা হাজি নবাতুল্য বেপাৰীৰ ঘৰত ফুৰিবলৈ আহুৰা 10 দিন মান ধৰি ওপৰত উল্লেখিত আসামে মোক নানা ধৰণৰ অশ্লীল প্ৰস্তাৱ দি আছে এনে নানা অশ্লীল প্ৰস্তাৱ দিয়ে এনে অৱস্থাত 8-5 তাৰিখে আবেলি অনুমান বজাত মই উক্ত মোৰ নানা হাজি জবাতুল্য বেপাৰীৰ ঘৰৰ সন্মুখত ৰাস্তাত মই থিয় হৈ থকাত উল্লেখিত 1 নম্বৰ আসামে মোক অশ্লীল প্ৰস্তাৱ দিয়াত মই অস্বীকাৰ কৰাৰ আসামীজনে মোক বলৎকাৰ কৰাৰ উদ্দেশ্যে মোৰ হাত ধৰি টানি চুচৰাই তেওঁৰ ঘৰত লৈ যোৱাত মই চিঞৰ বাখৰ কৰাত মোৰ নানী নুৰুমা বেগম আগুৱাই যোৱাত উল্লেখিত আসামীবিলাকে মোক আৰু মোৰ নানীক অশ্লীল ভাষাত গালি গালাজ পাৰি ডিঙি চেপি মাটিত পেলাই হাত ধৰি ৰাখি শৰীৰৰ বিভিন্ন ঠাইত জখম কৰে বৰ্তমান মোৰ জখমী নানী পানবাৰে অহাৰবাৰ চিকিৎসালয়ত চিকিৎসাধীন আছে প্ৰকাশ থাকে যে ভৱিষ্যত 1 নম্বৰ আসামীয়ে মোক মোৰ
Is there?
Yes, case diary received, lordship. Allegation is serious and that is the injured victim has grievous injury. The informant victim also has injury, but it is blunt in nature. And statements are there, and also the
Grievous injury, what?
grievous injury to the grandmother, which is stated in the FIR.
What
Who
is the
went
injury?
there to rescue the girl, the victim.
What is the injury?
The injury is lordship. Lordship, bruises in left wrist joint, invented movement. Pain is written movement left hip, point and lower back. X-ray report reveals displacement of this notil. Lordship, can you see?
No, don't give it to me.
Another
Bone replace.
bone, because she was fell down, Lordship, when she
But
went to
all-
rescue her.
But all these 3 accused persons are already in there, they are women, my lord. Who accused, my lord.
But here the
And
petitioner is the
regarding
primary.
354, all these sections are available. And regarding 354, my lord, our wife was present at the time of incident, my lord. And it is the case of daytime, my lord. The informant also implicated the wife of the petitioner, my lord, as a accused, my lord. At the time of incident, my lord, his wife was present in the house, my lord. How 354?
Yes, what is your submission? Where is the order of other petitioners?
Lordship, page, interim, page 16, my lord.
Let him appear if you don't want. You want his custodial detention.
Lordship, allegation is serious otherwise, and from the 161 statement and the witness.
11.5.
No grievous
No,
injury,
by
my lord.
falling dislocation.
Lordship,
The dislocation may be due to falling.
only
She
because,
fell on the ground.
no, because of, using force and all this.
No, no offense, lathi, no offense have been used, my lord. And the section put by the police major was not bailable, my lord.
Heard,
So in the interest of justice, lordship, kindly.
heard, Mr. What is your name?
S. Rahman,
S. Rahman, learned counsel for the petitioner.
any condition, lordship.
This application under section 438 of the Code of Criminal Procedure has been filed by the petitioner, namely Bullal Sheikh alias Rahul, who has been apprehending his arrest in connection with Mankasar PS case number 111 of 2024 under section 341/295/354/509/506/34 of the Indian Penal Code. The gist of accusation in this case is that on 11/5/2024, one Salma Yasmin had filed an FIR before the officer in charge of Kalapani Police Outpost under Mankasar PH Police Station, inter alia, alleging that on 8/5/2000.
But the FIR lost after 3 days, my lord.
Okay, on 8/5/2024. At about 3:30 PM, the petitioner gave indecent proposals to the victim / informant, and thereafter he held her hand and dragged her towards his house. At that time, the grandmother of the informant, Nurina Begum, came forward to rescue the informant. And the petitioner, along with 3 other accused persons named in the FIR, including the wife of the petitioner, had assaulted the informant and her grandmother, causing serious injuries on their persons. Learned counsel for the petitioner has submitted that in the meanwhile, the other 3 co-accused persons have already been granted anticipatory bail by a coordinate bench of this court. It is also submitted that, what is your submission?
But my lord, I have stated para 3 and 4, my lord. Actually, what happened, my lord? The informant, the accused number 3, my lord. Actually, the girl has the informant has a love affairs with the nephew of the petitioner and the other accused person. And when the incident is informed to the grandfather, that the grandfather got angry and used sling language to the informant. Thereafter, on 8/3, there was a quarrel between the petitioner and the informant, my lord. And on the
counsel for the petitioner has submitted that false accusation has been made against the present petitioner in the FIR. he also submits that the FIR has been lodged after a delay of 3 days without any explanation for the delay caused. It is also submitted by learned counsel for the petitioner that the petitioner would cooperate in the investigation. And as other co-accused are already granted bail and they have cooperated in the investigation, his custodial detention may not be necessary. On the other hand, learned additional public prosecutor has produced the case diary of Mankasar PS case number 111/2024 and has submitted that other co-accused statements are recorded, Mr. Bushaw.
Lordship,
Statements of other co-accused.
that is not available here.
Okay.
And
And has submitted that as the allegation against the petitioner is of serious nature.
Lordship, accused, yes, accused, yes, that is other co-accused statements are recorded.
Serious nature. He opposes the grant of bail to the present petitioner. However, he submits that the statement of other co-accused are already recorded under section 161 of the Code of Criminal Procedure. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor and have perused the materials on record, including the case diary of Mankasar PS case number 111/2024. Stop. As there is a delay of 3 days in lodging the FIR without any explanation therefore in the FIR, and as the other co-accused persons which includes the wife of the present petitioner also, who were already granted bail, anticipatory bail by a coordinate bench of this court, have cooperated in the investigation. This court is of considered opinion that if the petitioner cooperates with the investigating officer, his custodial detention may not be necessary for fair completion of the investigation in the above noted case. Hence, the petitioner, namely Bullal Sheikh alias Rahul, is directed to appear before the investigating officer of Mankasar PS case number 111/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Mankasar PS case number 111/2024, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Condition number 1 and 2. With above observation, this anticipatory bail application is hereby disposed of. Send back the case diary.
Highly obliged.
Also, here only the thing is that maybe because the grandmother who was injured, that time she was hospitalized and
Conditions are
Yes.
having.
Obliged. Item number 12.
Please, your lordships. Lordships, today is 58 days lordship. The allegation is under section 310. The case diary was published.
Lordship, here the search is completed in this matter, Lordship.
What is the offense?
Lordship.
Charge sheet submitted
Search is submitted.
against him.
Yes, Lordship.
Against me,
All five,
against all these shown arrested persons.
all five.
All these persons were shown arrested. They were originally arrested in this PS case number 87, and subsequently all these persons, 4 persons have been shown arrested in.
No,
86
you
cases.
go before the trial court,
Lordship.
make, or what is your submission?
My submission is considering the prolonged detention, Lordship, your Lordship may be kind enough to grant him bail, Lordship. And there is another case pending also, that is actually fixed on the actually on 19.
Okay, subject to satisfaction of the trial court.
Lords.
Heard Mr. Z. Hussain, learned counsel for the petitioner, also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Dilbar Ali, alias Dilbar Ali, who has been shown arrested in Hatigaon PS case number 86/2024 under section 380 of the Indian Penal Code on
21/5.
21/5/2024. That is within bracket last 58 days. It is submitted by learned counsel for the petitioner that the petitioner was earlier arrested in connection with Hatigaon PS case number 87/2024 on 8/5/2024. And considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that though case diary was called for, however, in the meanwhile, charge sheet has already been laid bearing charge sheet number
105/2024 under section 380 IPC
380 IPC.
on 36/2024.
Stop. Considering the fact that the petitioner has been detained behind the bars for last 58 days, and also considering the fact that the investigation has already been completed and charge sheet has been laid, the custodial detention of the present petitioner may not be necessary. Hence, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the trial court. Trial court. With following conditions: that he shall cooperate in trial and he shall not directly or indirectly make any inducement, threat, or promise. With above observation, this bail application is hereby disposed of.
Deeply obliged.
Let me the lordship. My 439 application, and I was arrested on 3/4/2023 and forwarded on 4/4/2023. Now, my petitioner before the lordship is a helper of a vehicle, my lord, which has a service contract agreement with a 4-year company.
Investigation is, charge sheet has been laid.
Charge sheet has been laid, Lordship. I have not gone through the entire, but to some extent I have gone through this report.
What is your ground?
My ground is that the container vehicle was sealed by the company having their own lock, my lord, lock number. So when the seizing officer stopped the vehicle, they found it is in intact position, my lord. There was no hampering or tampering with the lock. And now, my lord, the contraband which was recovered, because of that, I was arrested, my lord.
Charge sheet has been laid against whom?
Driver was also there, my lord, and I am the helper. And driver was, lordship was pleased to grant bail to the driver, my lord. Because while case diary was produced, lordship found, my lord, may I just take a lordship to paragraph, page 43, paragraph 10. That was the order, my lord, with regard to the bail application preferred by the driver of this vehicle, my lord. Page 43.
No, is there anything on record that the helper knew what is being carried in the vehicle?
Lordship, entire record I have not
Charge sheet
gone
has
through.
been filed against how many accused?
Only driver and yes, this person, my lord.
Not against the original
No, my lord, no,
consignor and consignee.
no, my lord. It could have easily been found, my lord, because this has a particular batch number, manufacturing, everything details was there, my lord. But these two persons were roped in, my lord.
If it is in sealed condition. You go through,
Yes,
how much time you take?
what's it, 10, 15 minutes, 10, 15 minutes.
We'll take it after some time. Or we'll take it tomorrow.
Day after tomorrow, if
Day
possible.
after
Day
tomorrow.
after tomorrow.
You go through.
Or if it is possible at 2, Lordship.
No, 2 we have already fixed some.
Okay.
Day after tomorrow. On the request of heard Mr. M. A. Chaudhary, learned petition for the petitioner. Also heard Mr. K. Gosher, learned additional public prosecutor, who seeks some time to go through the scanned copy of the case record which is available. And before he makes his submissions, the prayer is allowed. Let this case be listed again on 19th July 2020.
Item number 14 from daily list.
This is an appeal preferred by the present appellant against the judgment and decree dated 13/5/2019 passed by the civil judge Nalbari. It is a concurrent finding. The present appellant is a defendant appellant. The plaintiff has filed plaintiff respondent.
Whether substantial question of law has been framed.
Lordship,
Substantial question of law has been framed.
no, Lordship, on the last occasion
What
also,
notice was issued?
Lordship, caveat was there,
Caveat was there.
Lordship. On the last occasion, substance that has not been pleaded or in the mentioned in the memo of appeal. So that is why there is an order from the honorable court that the directing the appellant to submit the substantial question of law.
It has to be there in the memo of office.
Lordship. Okay.
How you have brought this substantial question of law on record?
My lord,
By submitting. No, the order was,
actually factum of the case is that
no, not factum, I'm on procedure.
Yeah.
Just help me to understand the
Yes.
procedure.
Lordship.
actually should land in question.
No, on that.
Not on that. I will go into the merit later on. First procedure, when you file a second appeal, your memo of appeal should precisely contain the
Substantial question.
substantial question of
Yes.
law, which perhaps is not there. I have
Not
not
there.
gone through, which is
Not
not there.
Not there,
No, yes, no.
not there.
Is
Actually,
it there or not?
should land has not been identified.
No. I have
No,
not
that is not the
observed
question.
that. What was the substantial question of law?
Whether that was in the play memo of appeal or not,
It was not there.
not there.
Yes,
It
I
is
have-
there.
yes,
Show me.
yes. All are in a memo appeal.
The
Where?
grounds, no?
Page number?
These are the grounds.
No, in a second appeal, can you take normal grounds?
No.
No,
You have to precisely mention the substantial question of law in your.
that's why I have to file a separate sheet.
Whether separate sheet would do, that is my question. or whether you have to amend your memo of appeal. Because court said that bring on record. Court only said that you may bring on record the substantial question of law. How you have to bring it on record?
Lordship.
By amending your memo of appeal.
Memo of appeal.
Because that is my understanding. You make me understand.
So
Whether
section,
he can give a loose sheet.
not actually loose sheet, but section 100 and subrule 3, subsection 3 says, section 100, subsection 3 says,
Memorandum of appeal shall precisely state. It has to be in the memo of appeal.
Lordship,
It has to be in the memo of appeal.
in the memo of appeal.
That's why, Your Honor, the Honorable Justice D. Borua has directed me to file a separate sheet, as I have not stated in the memo of
It is
appeal
not said.
specifically.
No.
It has not directed you to file separate.
No.
It has said that you can bring on record
Lordship. The substantial question of law.
substantial question. It has to be in accordance with the CPC.
Yes.
CPC say it has to be in the memo of appeal.
Memo of appeal.
So you have to bring it on in the memo of appeal.
In the memo
Or
of appeal.
that memo of appeal has to be amended,
Amended.
perhaps.
Lordship. That is the procedure.
Or what is your submission?
And today,
Yes, Mr. What is
Lordship.
your submission?
Lordship.
How we should proceed?
Lordship. Lordship, as per the direction given by the earlier order by this honorable court. So this memo of appeal, second appeal, that was
The
to be,
Order dated 28/6/2024
Lordship.
says that you can bring it on record. But you have to bring it on record
Record
as per CPC.
as per the CPC.
CPC says that it should be contained in your memo of appeal.
Memo of appeal.
I may be allowed to amend it.
Yes, that will be.
I will file properly.
Heard Mr. L.K. Bora, learned counsel for the petition, learned counsel for the appeal. Also heard Mr. R.K. Bhuyan, the caveator and the respondent. You have filed the caveat,
Caveat, Lordship.
learned counsel for the respondent. Learned counsel for the appellant has submitted that by order dated 28/6/2024. The counsel for the appellant sought for an accommodation from the court to bring on record the draft substantial question of law, which was allowed by this court. However, he submits that as section 100 clause 3, within bracket 3, provides that the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. He has to amend the memo of appeal and prays for leave of this court to allow some time to amend the memorandum of appeal because the prayer is allowed. Release this case after 2 weeks.
Yep.
In the meanwhile, the petitioner, the appellant may make the amendments in the memo of appeal as sought for by them. May file and may take necessary steps for amending the memo of appeal.
Item number 15. Please, your lordship. Lordship, this appeal has been filed, in fact, against a consequential decree. Consequential decree in the sense, lordship, the appeal was time barred.
Appeal was
First appeal was time barred.
time barred.
Time barred, and the delay was not condoned properly. Lordship, what happened? The total delay counted was 657 days, which was not condoned for certain reasons. But what happened, Lordship, meanwhile that the apex court's corona directions up to 28 to 22. Lordship, that period was not actually to be excluded, not excluded. This is one aspect. And the total period is much lesser than the 657 days if it is excluded. That is one aspect, Lordship.
No, if that
Lordship.
the period which was excluded by Supreme Court.
Yes, that was not
If
excluded.
it is excluded, then
Yes.
there is no delay.
Not excluded at all.
If, assuming that if it is excluded,
It
then
should have been excluded.
no, assuming that if we exclude that period, then will there be any delay or will it be within limitation?
Lordship, no. Even then there is delay, Lordship.
Even then there is.
Even then there is
How many,
delay.
how many days?
That delay is, Lordship, 232 days.
232 days. Then
Yes, Lordship. And the appellant's ground here was, Lordship, that when the execution notice was served on them, they could come to know about the decree which was passed ex parte. That means, Lordship, there is no evidence on record for the appellant's side to establish their case without even cross-examination. My Lordship, the humble submission is that Order 8 Rule 10 provides that even if WI is not filed, then also the defendant has a scope to participate in the proceeding. That is the settled law, Lordship, by the apex court. And Lordship, that was also not there. Because what happened, Lordship, it is something internal. The appellant before your Lordship is in fact a farm. In the Suitland, they have got one warehouse, Lordship, go down, which is taken on lease by the FCI, and that is there. Now, Lordship, so far the merit of this appeal is concerned, Lordship, it is such a plaint, Lordship, on which actually even if the suit proceeds ex parte, no decree or executive decree or legal decree could have been passed by the original court, that is the learned Munshi. Because, Lordship,
no, let me understand. In the trial court, in the trial court, you were the defendant.
I was defendant,
You
one
were-
of the defendants.
You were one of the defendants.
Yes.
And the suit was filed for,
Suit was filed for declaration of right, title, etc., for partition
and it was decreed ex parte against you.
against me. Lordship, others did not file because I am the victim. I am affected by
So
the
it was decreed ex parte.
decreed ex parte.
Then you preferred an appeal against that ex parte.
Yes, Lordship. When I come to know about the passing of the decree,
So
by
in
that,
that
Lordship,
appeal, the appeal was time barred.
appeal was filed.
You preferred a application under section 5,
Yes, Lordship.
which was not allowed.
This was not allowed. Only that is the reason. In fact, I was non-suited all along, Lordship.
Now, here, what is the substantial question of law?
Substantial question of law that, Lordship, even if Lordship may come to page 6.
You have given draft. You have
Yes, Lordship.
stated that substantial question of law.
Some proposed substantial question of
At page 6, your lordship may find. And to justify, I have for the time being, lordship, only the plaint. Even without evidence, lordship, on record or even if the record is called for, lordship, I have no evidence. But the plaint is there, lordship, before your lordship. Got it, lordship, at page 6 of the memorandum of appeal. At the very beginning.
Yes.
Lordship. First two, lordship. Those are the main points. Before your lordship, I have raised or put as a substantial question of law to be determined. To satisfy your lordship, I will just read over the plaint which is annexed.
No, but
Two is main thing, lordship, the main question of
is-
law, and one
two
is the
not
next
a
question of
substantial
law.
question.
From
Whether question number 2 is a substantial question.
lordship, because
Question number 2 is a question of law,
question of
which
law,
is settled.
yes,
which is
the
settled. He
question of
cannot-
law that has not been complied with. It was in fact a perverse.
Perversity is there.
Yes, perversity is there. Otherwise, lordship, had the learned trial court seen the plain properly, with no evidence on record, lordship, the decree could not have been passed.
There was no evidence.
Substantiating the plaint, lordship. There is evidence, but there is no such evidence, lordship. If your lordship permits me, lordship may kindly turn to page 39 where I annex the plaint. There are 2-3 points I would like to point out, lordship.
Yes, yes. Yes.
Lordship got it.
Page 39.
Lordship, in the subject, the suit for declaration of title, etc., interest, etc., plaintiff over the suit length. For the recovery of khas possession of the part of the land. So schedule 3B3, lordship, according to the plaint, in fact, is a land pertaining to DAG number 45, lordship, of the concerned party, which is schedule B1 and B. They say it that schedule B is the suit land. From B3, I am to be evicted.
From B3, you have to be evicted.
Yes, lordship. I am to be evicted from B3. B is the suit length, and B1, 2 are the shares of lordship, plaintiff 1 and plaintiff 2. They have jointly filed this suit. They cannot jointly file this suit because they are purchasers under different sale deeds at different points of time, years after lordship. How can
I could not get this point. Last
lordship? One is purchased, lordship. Plaintiff 1 has purchased the land in 97. Just from my record, I am submitting, lordship. And plaintiff 2, lordship, they purchased it in 2004. How can they join together to file this suit against me from schedule B3, lordship? That is what was the crux. And lordship had got it.
Yes.
Lordship.
So they filed a joint suit. In title suit,
In
There
title,
were,
yes.
there were two plaintiffs.
1 and 2 joined for partition of that particular. Partition of the particular drug is not the concern. Here, Lordship, I would like to take your Lordship to page 41. Just first few lines, Lordship.
Yes. Yes.
Page 41, Lordship. First few lines, Lordship, I am reading out. Here, your Lordship will be clear.
Yes, please read.
Lordship. But while executing the registered cell deed number such and such of 2004, that is the plaintiff two's Lordship, cell deed. The area of land was wrongly mentioned as 1 bigha 1 katha 2 lesa. Indeed did, but in fact, Dharonidhar had only 1 bigha 9 lesas of land within Schedule B. Because Schedule 45, Lordship, that number 45 contained, Lordship, only 2 bigha 9 lesas of land. Lordship may kindly take note of this. And 1 bigha was sold as back as in 1997, Lordship, to plaintiff number 1. So DR remained, it is a true statement of fact. So DR remained 1 bigha 9 lesa only. How can the plaintiff number 2 seller sell 1 bigha 1 katha 2 lesa? That is the admitted position, Lordship, that it is wrongly mentioned in the. So a partition how can be made, Lordship, if Schedule B of 2 bigha 9 lesa, in Schedule B of 2 bigha 9 lesa, Lordship, partition is sought for in 2 bigha 1 katha 9 lesa. This is one aspect. The other family aspect is there, Lordship. That is, the entire decree was in fact a perverse decree, Lordship, in spite of these admitted positions. Though I have no evidence to place before your Lordship, though there is no written statement, Lordship, even then from the apparent reading of the plaint, Lordship, it is revealed that they have purchased, both have joined and asked for partition.
But you are not against the decree.
Lordship.
You are against the rejection of your condonation of delay application.
Lordship, all those things are there. Basic question is that, Lordship, such a decree cannot be legally passed or it is not legally sustainable. In any case, even if this decree is passed against me, ex parte. Ex parte, there is nothing like, Lordship, ex parte. I ought to have been given an opportunity of hearing by participating in the proceeding. This is one aspect. I am not on this point to, Lordship. If this decree is, Lordship, sustained, then, Lordship, there will be tremendous hardship on my part. One thing is that they have been in 2 bigha 1 katha 2 lesas of land, where the duct contains only 2 bigha 9 lesas. This is one point, Lordship. Nextly, Lordship, if they have purchased as back as in 1997 and 2004, my Lord, one thing, how can be possession delivered to me by the seller? The seller is a title holder. So far I am concerned, Lordship, my seller is a title holder, as they are sellers. They are joint partners of, as legal heirs of one Zamalaram Kos. If the record is called for, Lordship, even without.
Before calling for record,
Lordship,
we have to jump the hurdle of substantial question of law. This is a second appeal.
This is a second
appeal. And you are impugning the order of rejecting your prayer for condonation of delay.
Condonation of
delay.
That is their, Lordship.
In that rejection order which you are assailing here, there must be some substantial question of law.
That
so
is
as
true.
to admit this.
That is true, Lordship. This part is there.
I have understood that
I absolutely agree,
in
Lordship.
trial court, according to you, has passed an perverse decree without
Yes.
looking into the,
Yes. At this moment, Lordship, the question is of the continuation of delay. If that is considered, then these things come. Assuming, Lordship, assuming this is the order is passing that, not condoning the delay, Lordship. Assuming that is correct, then also this other part remains. So it has to be treated as a whole, Lordship, to consider that even delay condonation. I was actually not served with any notice in that sense. Because, Lordship, the person who represented himself, that is another part. He played his role for the plaintiff, assuming to be my agent. That is this thing, Lordship. He applied for filing WS, time for filing WS, etc. He did everything. These things are remain, Lordship, still. And I am prejudiced.
no, you have some authority. That
Yes, Lordship, I have got possession. Still, I am in possession of the property. Schedule B3.
they have filed execution case.
Lordship,
Have they filed the execution case?
they have filed the execution case. That is why only on that point we could come to know that a decree has been passed for my execution.
No, my query is when you have come challenging the
I have got.
dismissal of your condonation of delay application.
That is, I am agreed, Lordship, that order is also in a
Therefore,
sense,
this is second
in a
appeal.
sense not proper. I am pointing out, Lordship, because on the last occasion, His Lordship D. Borua wanted that what is your point? This is one point. What is your point on the main question? Because you don't have evidence or even WS in the case. That is what was his question, Lordship. His Lordship was pleased to just consider on those also at the same time. That is why I am submitting.
No, I need some authority from your side. You assist me in understanding that in second appeal filed against rejection of delay condonation petition,
Lordship.
the second appellate court can consider the trial court's error also.
Lordship, so far, your Lordship is quite aware of this legal position that substantial justice is the first concern, then the point of limitation, Lordship. So far, limitation part is concerned, if the substantial question of substantial justice is to be considered, Lordship, delay has to be condoned or the matter of delay should be considered liberally, Lordship. That is the settled law, Lordship. And my question is that when I had no knowledge, Lordship, in that sense, so from the date of knowledge, I had in fact no delay. But actually there is, as per record, a delay. And that delay
Because the
was
substantial question of law which you have framed,
for the time being, Lordship.
which is there in the memo of appeal.
Memo of
You-
appeal, Lordship.
You have framed you have suggested three substantial questions of law.
I have settled this, Lordship,
At page
because
6, at page 6,
six.
at page 6, you have suggested three substantial question of law.
Yes, Lordship.
This relates to the trial court.
This relates to the trial court because, Lordship, one more question, Lordship. If I am given liberty, if your Lordship is pleased to consider the delay application or on that count remand it, that is a different issue, Lordship. I am not pressing that way. It is up to your Lordship to see the things that way. So far, this court is concerned, Lordship, in appeal, that delay condonation was not properly considered in view of the apex court direction. Had this been considered, Lordship, delay.
Can that be a substantial question of law?
No, that is not the substantial question. For this purpose, that is not the substantial question. If that delay, for filing this appeal, there was no delay. So if that is the consideration, Lordship, delay was not considered properly. Then if that is there, Lordship, the next case will be, it is a hit case to be remanded. That is another aspect. And as per record, exactly, Lordship, 657 days delay was not there in view of the apex court judgment in view of that corona pandemic.
Then we will take it up. I have to go through. You also assess this court
Lordship.
that in a second appeal, where grievance is against the delay condonation or rejection order, what would be the substantial question of law?
Had the delay been condoned, Lordship, it is improper. Had the delay been condoned,
Then
Lordship,
first appellate court could have considered
first,
these
all the
questions.
issues.
All the issues,
All the issues.
this could have been considered by the first appellate court.
Yes, at
Now,
least.
these are not, whether this can be the substantial question of law before the second appellate court also.
That is, dear Lordship, when some settled law is not observed or not followed, Lordship, by a subordinate court, then Lordship,
But
definitely,
that is for the first appellate court to consider.
yes, first appellate
But
court.
first appellate court could not consider because of the delay.
Yes, at the threshold, Lordship, my delay was considered to be the delay without considering the other circumstances. Because
Okay.
it is the discretion of the,
It would mean that first appellate court has confirmed by rejecting your delay condonation petition.
yes, that is one aspect.
Would it mean that it has confirmed the decree of the
Then,
trial
Lordship,
court?
yes, then Lordship, the court should have or court could have considered whether the decree passed was proper or improper. By not condoning the delay, Lordship, in fact, the learned first appellate court had washed its hands from considering all these.
Okay, then I'm not passing any order now.
Lordship.
You come with some
Lordship, maybe.
authorities
Lordship, maybe.
day after tomorrow or next week, whenever it is convenient for you.
Tomorrow, if your Lordship considers, I will.
You answer my query that
Yes, Lordship.
under such circumstances,
Lordship.
what would be the substantial question of law? What would be the substantial question
This is the dilemma I have got also, Lordship.
that I'll also go through you
Yes,
also?
in one hand, Lordship, the point of limitation, had it been considered their court, then the substantial question of law could have been properly formulated.
Yes. Now, whether substantial question of law can be formulated if your delay condonation has been rejected,
Then, Lord,
what would be the substantial question of law under such circumstances? That is my
If
query.
delay is, if delay.
Not today. Day
Not
after
today, Lordship.
day
Not
after
today,
tomorrow.
not today, Lordship. No, I agree, Lordship.
Third, Mr. L. Talukdar, learned counsel for the appellant. During the course of submission, a query was put to learned counsel for the appellant as to when the second appeal has been preferred under a situation, in a situation when the delay condonation application, when there was a delay in filing the first appeal and the delay condonation appeal has been rejected by the first appellate court, as to what would be the substantial question of law under such circumstances. Learned counsel for the appellant sought some time to go through to response to the query posed by this court.
Lordship, very crucial point.
The prayer is allowed. When should we fix it?
Day after tomorrow, if
Let
your
this
Lordship
be-
considers,
Let this case be listed again on 19th July,
tomorrow will be too early.
19 July, 19 or 20, whenever it is.
Lordship.
Whenever it is convenient for you, because
Let me see, Lordship. Just a minute. Sorry for that. Huh? 19. Maybe today after tomorrow, no 19. 23rd
23rd, let this case be listed again on 23rd July.
obliged. Lordship.
May I please, Your Lordship? Lordship, with regard to item number 42, Lordship. Lordship had directed me to take, to
Consent.
inform the other side, yes.
You have
Petitioners
informed.
again.
You have no objection.
No, I have no objection, but there is an interim order.
You have objection.
No, I don't have any objection. He has got some personal problem.
Heard, Mr. What is the name?
P. Mujumdar, Lordship.
Heard, Mr. P. Mujumdar. Item number 42. Item number?
42,
Heard, Mr. P. Mujumdar, learned counsel for the respondent.
1 to 5.
Number 1 to 5. Who prays for an
Sorry, 1 to 6.
1 to 6.
1 to 6, Lordship.
Who prays for an adjournment on the ground of personal difficulty. Mr. A. Purkas, the learned counsel for the petitioner, does not have any objection. Hence, the prayer is allowed. Let this case be listed after
15th of August, no, any day.
after 3 weeks.
After 3 weeks.
After 3 weeks, the interim order shall continue till
Continue.
next day.
Obliged, Lordship.
Item number 48.
My lord, will kindly see the last order. Twelve 6/24.
What order has been impugned here?
Well, there's an order passed under, they had objected to an attachment. My lord. Briefly put, my lord, the pro forma respondent here, my
Who
lord.
are you
I am the respondent, my lord.
in the trial court?
In the trial court, I am the award holder, my lord. I'm the
Decree holder.
decree holder. So, my lord, the pro forma
The
respondent.
case is pending at the execution stage.
At the execution stage, I had obtained an arbitral award for an amount close to 3 crores now. And I had, after a long drawn process, it was challenged up to the Supreme Court. And Supreme Court eventually said that the execution should be completed as soon as possible. Now, in the course of those
This the execution case in respect of that
arbitral award, that's right. So, my lord, a writ of attachment was issued, my lord, in respect of several properties, my lord. At that precise juncture, my lord, the bank steps in, the State Bank of India. Now, State Bank of India claims that they also have a recovery certificate against the pro forma respondent, and few of the properties which are within that attachment order have already been mortgaged to the bank. So basically, pro forma respondent owes money to both of us, and they say that my attachment orders covers a few properties which are already mortgaged with the bank. So that was the precise objection before the executing court, which the executing court has rejected, which is why they are here, my lord. Now, my lord,
Why, on what ground it was rejected?
or they say, my lord, that these are mortgage properties. Perhaps they claim priority that we should recover it first and then our turn should come. Now, we will not trouble your lordship with the issue of maintainability. We've raised all that also. Today, we are here only for a partial modification of the order, which the last order had also given us liberty, my lord. Now, out of all those attached properties,
What was the last order? What interim relief was granted?
my lord will see the last.
You are respondent in this.
I am the respondent. He was a third party objector in the execution proceeding. My lord, the last portion of the order, if your lordship sees,
What was the
the attachment order. Further proceedings were stayed, my lord.
attachment of what?
Attachment of immovable properties belonging to the pro forma
All
respondent.
immovable.
All immovable properties. Now, therefore, it was clarified in the
In
last,
which property they are interested bank
they are interested with 27 numbers of properties.
out of those?
Out of those. Now, we've brought that distinction at page 362 of my affidavit. I have depicted the properties which are part of the attachment, but are not part of the mortgage properties.
Where you filed any affidavit?
Yes. 362, if your lordship sees. These four properties, my lord, which have actually been attached, are not part of the mortgage properties. So our limited prayer at this juncture is that insofar as these properties are concerned, let the execution proceed at least qua these properties. Because these are not part of the recovery certificate, which your lordship finds at page 88, the list. That is by the DRT. 88, there's a list of 27 properties. So barring these 27 properties, ideally there should be no embargo for us to proceed in respect of the other properties.
Of your affidavit.
88 of the writ petition, they're numbered, I'm sorry, the CRP.
There is some order.
Yes, this is the recovery certificate was issued in favor of the bank. And the last paragraph, the charge of the certificated amount be kept alive on the mortgage properties, that is A to ZA, Manoj. The properties are mentioned. So even if their claim is to be accepted, Manoj, the execution shall not proceed only in respect of these 27 properties. So those four are not covered. So my limited prayer at this juncture is, since those four properties are not with among your mortgage properties,
The execution may
proceed in respect of that.
You have in your
May I please proceed? My proposal is that let this CRP be allowed with order that what is the property mortgage with the bank should take steps before the recovery officer.
No.
Admittedly, the property is mortgaged, there is an order of a competent court. And our objection was there that we are having original application against those properties. We are having certificate. So if they are admitting that those property are mortgaged, then there is no harm. We will proceed before the recovery officer DRT. And with respect to these four property, they can proceed. The order cannot be passed in piecemeal way.
No,
basis. Because you are having a certificate for rupees 27 crores here.
Lord, there I'll just submit, my lord.
Admittedly, the property is mortgaged with the bank.
Here service is complete. All the parties are before this court.
Barring the pro forma respondent who will probably not appear. He's been absconded. I mean,
Actually, he has given false affidavit before the Honorable Calcutta High Court, suppressing that these properties are mortgaged.
no, he had disclosed that a few of the properties are mortgaged.
Whether service on pro forma respondents are necessary.
Manoj, so far as this modification as per the last order, because last order says that if we can show that there are other properties, the interim order will be modified suitably. Manoj.
No, he is submitting.
He wants a disposal, Manoj. The only difficulty with the disposal is this, Manoj.
Therefore, I am putting queries.
Yeah.
Whether service is complete. whether
Yes, my lord.
At what stage it is pending.
Now, I have taken steps. They have not appeared.
So therefore, let the
I have
CRP
taken-
remain, my lord.
Has to remain.
It has to remain, my lord, because we have other arguments to advance also, which I'll not trouble. Because we would say that the revision itself is not maintainable.
You will challenge the maintain. You will raise the maintain.
Yes, definitely, ma'am.
Let them file. I will satisfy the Honorable.
Yeah, so-
Then we will consider the interim prayer only today.
Yes.
Interim.
No, my lord, because we are also having certificate for rupees 27 crores.
No, but. on
They are
last-
having
last-
money execution case,
last
and we are.
order- Last
And I-
order while granting stay, there was an indication
Yes, ma'am.
in the last order itself. That the question of suitable modification of the interim order shall be considered after filing of the affidavit by the respondent. So
My lord will clarify that insofar as mortgage properties are concerned, they remain stay. And only these four properties can be gone ahead.
My lord, what is the use of staying the mortgage proceeding before the DRT? Because civil court is having no jurisdiction. and he is having only money execution. He has filed their money execution case. And your lordship
So
well
what
aware
is-
that
what
they are
has been said?
My lord.
Money execution case pending before the district judge.
district judge.
Durham
Yes, my
has been stayed.
yes, for execution proceedings, I believe.
And we are having certificate against the,
No, that is fine. My lord, they have a certificate. My lord,
having
we are not
certificate.
disputing that.
His proposal is
we are also having claim over that property because our certificate is for rupees 27 crores.
but that property is not specifically mentioned in the attached,
Only mortgage property. No, what
has
is
not
my
been
proposal?
mortgaged to you.
Yes, my lord, what is my proposal? If they want disposal, if they are in hurry, why not we should be in hurry? We
No,
have
for
filed
that
an
service
original
has to be-
application in the year 2016.
Service has to be completed on the remaining respondents.
So, yes, order may not be modified. And they are not appearing in fact. Even before the Supreme Court, they are not appearing.
No, then you take us to that stage where we can proceed ex
Ex
parte
parte
against them.
Then I may be allowed to publish notice in the newspaper.
But by now you have taken steps on last date was the first date.
On
Yes,
14 I have a
That
14.
was the first time the CRP has been.
Yes,
made
it had come up for motions. Motion.
And notices were issued.
Correct.
Registered post with AD.
Yes.
There is no. We will await service report as regards who are before us today.
The award holders, my lord. 1, 2, and 3.
Respondent number
1, 2, and 3.
123. 4, 5, and 6 is awaited. 4, 5, 6, and 7.
Yes, yes, they're away.
What is your name?
A.
Mr.
Parvez.
Parvez. Heard Mr. A. Parvez, learned counsel for the petitioner. Also heard Mr. I. Thakur,
BD Decamini.
B.D. Deka,
I filed it today. Papa.
learned counsel for respondent number 1, 2, and 3. The service report in respect of respondent number 4, 5, 6, and 7. You have taken steps
Yes, ma'am. I have paid.
when?
On 12th June. 14th June.
Learned counsel for the petitioner has submitted that the petitioner has taken steps for service of notice, for issuance of notice on respondent number 4, 5, 6, and 7 in pursuant to the directions of this court by order dated 12/6/2024. From the office note dated 15/7/2024, it appears that the notices issued to 4, 5, and 7 have returned back with some endorsement of Postal Department. In notice against respondent number 4, it has been mentioned that address of the addressee is not sufficient. Similarly, as regards notice, as regards respondent number 5 and 7, the endorsement is there within inverted comma, address moved. You have to give fresh new addresses.
Register post.
No, the addresses are insufficient. That is the endorsement of the postal department.
Well, this is the address available in the record of the case.
Then you take steps by alternative mode.
Alternative, that will be better. So we have taken the steps.
As regards respondent number 6, neither AD card nor answer notice have been received back. Learned counsel for the petitioner has prayed for taking steps for issuance of notice on respondent number 4, 5, and 7 through substituted mode by paper publication.
Paper.
By paper publication. the prayer is allowed. The petitioner shall take steps for service of notice on 4, 5, and 7 through publication in two newspapers, one vernacular, one in English, circulated within the state of Assam. Fixing what should fixing 19th August. 19th August. As the next date of as the next date in this case. As regards respondent number 6 is concerned, await service report. It appears that learned counsel for the, it appears that the respondent number 1, 2, and 3 have filed an addition. This is your
Affidavit in opposition.
affidavit in opposition. In file affidavit in opposition, wherein at annexure K, they have mentioned 4 properties. Four properties. As follows: quote A, B, C, quote 1, 2, 3, and 4 from page number 362 and 363. It is submitted by learned counsel for the petition, respondent number 1, 2, and 3, that in respect of the aforesaid properties, there is no mortgage. In respect of aforesaid properties, there is no mortgage with the respondent number, with the petitioner. And same is not the subject matter of the subject matter of what?
Recovery certificate.
Subject matter of recovery certificate issued by DRT Guwahati.
Yes.
Hence, he has prayed, hence learned counsel for the respondent number 1, 2, and 3 and has prayed that the interim stay granted on the
12/6/24.
on the further proceeding of money execution case number 2/29 by order dated 12/3/2024 by this court may be modified and the aforesaid 4 properties may be excluded from the purview of the interim stay order. What is your submission? You are opposing?
My lord, we are also having personal decree against these respondents, pro forma respondents. So we are having first charge because the loan was given in the year 2012. And we are having a degree for rupees 27 crores. 27 crore 30,68,318.
By the DRT?
Apart from, yes, by the DRT.
Learned
The
counsel
respondents
for
are also personally liable to us.
Learned counsel for the petitioner has opposed the prayer for modification of the interim stay granted by this court. on 12/6/2024 on the ground that the decree in favor of the petitioner is to the extent of rupees
3 crores. To us, yes, 27 crores,
27
30 lakhs, 68,318.
27 crore 30 lakh
22.
60 lakhs 27 crores 30 lakhs
68,000,
68,000
318
318.62
and paise 62
and
with future interest.
and they have also personal
Decree against the pro forma defendants. Apart from mortgage property, we are entitled to recover from their personal property also.
that apart from mortgage, he also submits that apart from mortgage property with the bank, the remaining, the other remainder may be recovered from the other personal properties of the respondent number
4, 5, 6, and
4,
7.
5, 6 and
4, 5, 6, and 7. Right.
My lord, 5 and 7. 5 and 7. And there is no property in the name of respondent number 6.
5 and 7. Where is that certificate?
Page 77. 77 of the CRT.
I have considered the submissions made by learned counsel for the petitioner has also submitted that this revision petition may be heard and disposed of finally without making any alteration in the interim notice. I have considered the submissions made by learned counsel for both the sides. As the notices issued to respondent number 4, 5, 6, and 7 are yet to be served. This court has to wait till the notices are duly served on the said respondents before the criminal revision, before this revision petition may be finally heard and disposed of. However, considering the fact that the petition, that the respondent number 1, 2, and 3 also have a right to enjoy the fruit of the decree obtained by them in title suit number.
In arbitration.
In arbitration.
The arbitral award dated 8/5/14.
In arbitral award dated
8/5/2014.
854 and rest for execution of money execution case number
2 of 19.
2 of 19 to its logical conclusion. And also considering the fact that the recovery certificate issued by DRT Guwahati is in respect of 27 properties only, as mentioned in its serial number within bracket small a to within bracket small 2
ZA.
2 ZA within bracket small z a small a to within bracket small
Capital A to capital Z A.
not capital A, it is small a.
in my,
Page number 12.
in my petition, it starts from.
Page number 12.
Achha, this one.
In page number 12.
12.
Small a to small
Z.
a. Where, what was the last name? Where the four properties mentioned herein above are not the subject matter of the said recovery certificate. Therefore, this court is of considered opinion that at least in interim, those four properties need not to, is of the considered opinion that for the ends of justice, the aforesaid the interim order issued on 12/6/2024. No. That the aforesaid four properties may be excluded from the purview of the operation of interim order granted on 12/6/2024. And therefore, this court orders accordingly. Let this case be listed on 19th August.
And the money execution case can proceed insofar as those.
Yes, before that. And the money execution case number 2 of 2019 may proceed in respect of the aforesaid four properties. Let this case be listed again on 19th of August.
Deeply obliged.
Timing item number 9.
Yes.
Lordship, we have filed our objection that objection may be considered, Lordship.
Length of co-accused is also released on bail, my lord. If it's number 18.
Where is your objection?
It's number 18, my lord.
How much delay is there? What is the period of incarceration?
My period is 1309 days today.
How much?
1309.
In years.
In years, 3 years, 7 months.
3 years, 7 months. And what is the stage of trial?
This evidence, my lord.
How
The
many-
evidence, first evidence started 21/9/22. And after that, after 8 days, then 1/10/22, 29/10/22, 22/11/22, 20/12/22, 17/1/23, 10/2/23, 15/23. No witnesses for it, my lord. After that, on 12/4/23, one witness is examined. And then it was fixed for 10/5/23, no witness for it. 14/6/23, the second witness for it. After that, no witnesses for it. And total date for evidence is 22 days. Up to 12/7/24.
How many witnesses are there total?
9 witnesses.
Out of 9, how many have been examined?
2 is examined.
Only 2.
Only 2.
Mr. What is the name? Mr. G. Pathak, learned counsel for the petitioner. also heard Miss M. Dekas, learned counsel for the Narcotic Control Bureau. This application under section 439 of the Code of Criminal Procedure from 1973 has been filed by the petitioner, Suresh Ram, who has been detained behind the bars since 16/12/2022, 2020, within bracket, for more than 3 years, 7 months, in connection with NDPS case number 28/2021, corresponding to NCB crime number 18/2021, under section 8C /20 B2C /29 of the NDPS Act 1985. The gist of accusation in this case. Who is the co-accused?
Co-accused Provoras Das.
Gist of accusation in this case is quote para 3 from
Provoras, Elias Provoras.
3 from page number 19. Three, 4, 5. In 6, instead of 3 years, 4 months, mention 3 years, 7 months. 6, 7. 8, 9, 10. On the other hand, on the other hand, Ms. M. Deka, learned counsel for the NCB, has vehemently opposed the grant of bail to the petitioner and has submitted that the Narcotic Control Bureau has filed a written objection opposing the bail for the bail of the petitioner on the ground that the quantity of ganja recovered from the possession of the petitioner is of commercial quantity, and therefore the embargo of section 37 is applicable to the instant case. Section 37 of the NDPS Act 1985 is applicable to the instant case. And until that embargo is overcome, the petitioner may not be granted bail. Stop. Learned counsel for the NCB has also cited a ruling of the apex court in the case of Union of India versus Ajay Kumar Singh alias Pappu, reported in, no, within bracket, within bracket, SLP criminal 2351/2023, wherein the apex court has observed as follows. Court in red paragraph from page 32. The counsel for the NCB has also cited ruling of the apex court in the case of Narcotic Control Bureau versus Mohit Agarwal, within bracket, appeal numbers 1001-1002 of 2022, arising out of SLP number SLP arising out of special leave to appeal within bracket criminal number 6128-29 of 2021. As well as also stop, no, not as well as the counsel for NCB has also cited a ruling of the apex court of India in the case of State by Inspector of Police versus V. Ramu, where and in the all the aforesaid cases, the prayer for bail of the petitioners were of the accused were rejected by the apex court on the ground that the quantity of contraband in those cases where commercial quantity and the embargo of section 37 would be applicable in such cases. I have considered the submissions made by learned counsel for rival parties and have also perused the materials available on record. Stop. I have also gone through the rulings cited by learned counsel for both the parties. Quote para 19 from page number 24. Quote para 23 and 24, 25, 26, 27, 28. No, 27 no code. 28. 29, 30, 31. In the instant case also, the petitioner in the instant case also, the petitioner has been detained behind the bars for more than 3 years, 7 months. And only 2 out of 9 listed prosecution witnesses have been examined till date. And during entire period of 3 years, more than 3 years, 7 months, the petitioner has been detained behind the bars, and there seems to be no fault on the part of the petitioner, which has caused delay to the trial. Which is pending against the present petitioner. Para 34, para 33, 34. $50,000 with 2 sureties of likeness. With certain clauses.
Item number 70. May please, your lordship. My lord, in the second appeal, my lord, we have framed substantial questions of law. The respondent is the plaintiff and the appellant, present appellant before lordship is a defendant.
Yes.
The present appellant is the defendant in the suit, my lord. And the suit was for, my lord, recovery of possession by eviction and right title interest. So for right title interest, my lord, we have nothing to say, my lord. My lord, rather we admit their title. But only point is that I being a tenant and the plaintiff being a landlord, they cannot directly file a suit for recovery of possession by eviction, my lord. That was our point, my lord, and on that point we have framed substantial questions of law.
Where is the substantial question?
My lord, in the memo of appeal we have enclosed, my lordship will find in the top, I think.
These are not questions of law.
My lord.
All are not questions of law.
My lord, I have given substantial questions of
Okay,
law.
point out.
In the top of the my lord, memo of appeal, my lord.
At which page?
My lord, in the before the cost title, my lord, it is enclosed, my lord. I think. In the opening, my lord, in the opening, substantial question of 3 questions we have framed.
Where? It has to be in the memo of appeal.
My lord, it is part of the, my lord.
Where? I am not finding it.
My lord, may I see the record, my lord?
Yes. Yes,
Yes, my lord. My lord, these are the substantial questions, my lord.
Read out the first.
My lord.
First substantial. Read out the substantial questions of law, which you have framed.
Huh? My lord. Substantial, first point, my lord. Substantial questions of law arises as to whether the suit so far relates to decree for eviction is rightly entertained and decided, ignoring own admission of the plaintiff that the defendants are his tenants, occupying and cultivating land on payment of rent, ignoring the provision of provision under section 54, subsection 4 of the Assam Temporary Settled Areas Tenancy Act 1971, read with section 51 2C of the same, whereunder suit for eviction ejectment is barred unless at first a decree for rent has been obtained, and that being not done,
and that too without framing any issue on this point is sustainable law. And that is the the law is very clear, when there is a claim for eviction by recovery of possession by eviction, then on the dispute of rent, then he is to file.
54.4 says.
My lord.
54.4.
My lord, yes, my lord.
Read 54.4.
54.4. Yes, my lord.
Of the Assam
Tenancy Act, my lord.
Tenancy Act.
Lordship may kindly have a look at the provision, my lord. I am having the book, my lord.
Yes, please read out.
My lord. Procedure for ejectment. Section 54, my lord. I am reading subsection 4, my lord. No suit for ejectment on ground of mention in section 51(2)(c) shall be entertained unless at first a decree for rent has been obtained.
In
So,
this case,
if there is, my lord, if there is a claim of non-payment of revenue rent, my lord, then he should file a case for recovery of the rent. If not, my lord, then he directly cannot file a suit for recovery of possession by way of, my lord, eviction, my lord. And the pleading is very clear, my lord. He also claimed that I am cultivating his land on payment of some rent. And I also admit that, yes, I am his tenant. And he should go for first for claim for recovery of rent.
now whether this plea was taken before first.
Yes, my lord. Yes, my lord.
First appellate court.
My lord. Yes, first appellate court also, my lord. My lord, in the suit also. My lord, kindly have a look at my WS Annexure B, relevant paragraph, lordship will find at page 14. May I read out, my lord? Page 14. Real facts in brief are that, my lord. Land under Dag number so-and-so covered by period of pattern number so-and-so.
You
Originally,
take that specific plea.
my lord.
That 54.4 was ignored.
Yes, my lord.
Where that plea was.
Yes, my lord. That is in the last portion, my lord, of page 14. The plaintiff came to the court and filed this case against the defendants for recovery of first possession straightway without claiming any mean profit. Indirectly, my lord, he is saying that he should go for recovery of rent first. Then, my lord, the suit can be filed. And the trial court as well as the first appellate court never issued a claim on this point, my lord.
And second and third.
My lord.
Now, Mr. S.H. Sigler, learned counsel for the appellant. This in appeal has been preferred by the appellants against impugning the judgment and decree dated 8/2/2024, passed in title appeal number 1/2022 by the Court of Learned Civil Judge, Senior Division, Baksa, whereby the whether trial court judgment was dismissed or
My lord, decree was suit, my lord.
Dic-
Decree was, my lord, suit was decreed, my lord,
suit was decreed and
My
it
lord.
was affirmed by the appellate.
without framing the issue on this point, my lord.
Dismissing the appeal and affirming the judgment and decree of the Learned Munsif Baksa in title suit number 6/2019. I have heard Learned Counsel for the appellant and have perused the materials available on record. And after considering the materials, following substantial question of law is framed in this second appeal. Whether the first appellate court as well as trial court have erred in ignoring the provisions of section 54 within bracket 4 of the Assam within bracket temporarily settled areas bracket close Tenancy Act 1971, read with section 51 within bracket 2 within bracket C of the said act, whereunder the suit for ejection is barred unless at the first instance a decree for rent has been obtained. Only this question is enough.
Sufficient, my lord.
Things.
Any other maybe framed in the during course of hearing.
Issue notice to the respondents. The appellant shall take steps for issuance of notice on the respondents by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. List
Well,
this,
I have a miscase, my lord, for stay the operation.
list this case accordingly.
1844.
Whether any execution case has been filed,
Not executed as on today, my lord. So far, my
whether
information,
it has been filed,
my lord.
not yet filed.
I don't know, my lord. Execution report is not coming to us, my lord.
No, and what will you stay? You have to stay the execution only,
Yes, my lord.
unless execution.
My lord, see, the land is still in our possession, my lord. So I am in possession, my lord.
Then
So
we
no
should-
execution, my lord.
Then in this case, we can only issue notice, no stay now. Because no execution is there.
My lord,
In second appeal, you can stay the execution only.
my lord.
What has to be stayed?
My lord,
Order 41 rule 5.
my lord, yes, my lord.
If there
Admission
no
is sufficient.
Case, what shall this court would stay?
My lord, they may go for eviction, my lord.
Then you come before this court.
My lord, my lord, we are still in possession of the land, my lord. So, my lord, if stay is granted, my lord, nothing will be
What should I
prejudice.
stay? What should I stay? Tell me.
My lord, they will go for eviction, my lord.
No, maybe. But what order do you want?
My lord, at this, my lord, status quo as regard the possession, my lord. That should not be disturbed, my lord. At least this much is sufficient, my lord. Status quo as regard the possession. Yeah. We are in possession, my lord.
Let us see order 41, rule 5. What is the legal provision?
My lord, lordship may issue notice in the miscase, but status quo as on today, my lord.
Status. When there is no threat. We can only say the execution of the decree.
My lord, yes, my lord. My prayer is also, my lord, to stay the execution, my lord.
Of the decree. But now there is no stay pending. We will issue notice.
Huh?
On the next date, we will see if there is this interlocutory application under order 41 rule 5 read with section 151 slash 151 of the Code of Civil Procedure has been. Now, whether staying the operation of impugned judgment and decree, whether we can stay the operation of impugned judgment and decree, or we can stay the execution. That is
My lord, my lord, when lordship is, my lord, admitted for hearing, my lord, it's a natural consequence, my lord. There shall be some
natural consequence. There has to be some provision in the CPC.
my lord, yes, my lord, provisions are there, my lord.
Show me that provision.
Order 41, my lord, rule 5, my lord.
What it says.
Petitioner line.
That what is I am asking. What we can say. Court can only stay the execution of the decree.
My lord.
But you're yourself saying that no execution case is pending. Decree cannot be executed. So we are issuing notice.
My lord, only my lord, status with regard to the my lord position I1, my lord. My lord, since we are in position.
No, you are in position. Let the respondent appear.
My lord.
Whether he has filed any execution case or not. Issue notice to the respondent opposite parties. The petitioner shall take steps for issuance of notice on the opposite party by registered post within 2 days from the date of this order. The returnable within after 4 weeks. List accordingly.
My lord, my lord, subsection rule 5 of the 41, my lord, clearly put stay of the appellate court's order, my lord.
What it says.
Yes, my lord.
That I was asking.
My lord.
What it says.
My lord, it says that an appeal shall not operate as a stay of the proceeding under the decree or order appealed from except so far the appellate court may order nor shall execution of a decree may be stayed by reason only of an appeal having been preferred from the decree, but the appellate court may for sufficient cause order sufficient cause order stay of the execution of
Stay of the execution.
Yes, my lord.
But now, no, you yourself said that no execution case has been filed.
Yes, my lord. My lord, taking for order. Thank you.
May be the lordship. My lord, as per order dated 25/24 lordship, respond number 1, 2, 3, 4, 5, 6, and 10 already appeared lordship. And so far as lordship 7, respond number 7 lordship, no service report regarding report regarding service of notice, Lordship. And 8, Lordship, we have to take phase state, Lordship, because AD card of respond number 8 has not yet been received back. And Lordship, respond number 9, it shows that office note shows that he expired, Lordship. Since Lordship, respond number 9 did not contest the case in the tribunal, he may not be struck off. Respond number 9 is the driver of the one of the vehicle.
Against him, is there any
No, Lordship.
against owner?
Against the insurance, we are paying 2 vehicles are involved, Lordship.
And the direction is. to the
Direction
insurance
is
company.
asked to us to pay. Whereas
You are the
Lordship,
insurance company.
yes, Lordship, I am the appellant in this case.
So driver, we can strike it out.
Yes, Lordship.
Heard Miss.
M.
What is your name?
M. Chaudhary, Mamuni
Heard
Chaudhary.
Miss M. Chaudhary. Learned counsel for the appellant. Also heard Mr.
Yes, I'm for, it's on 10, Lordship.
Also heard Mr. A. Ahmed. No,
R. Goswami, Lordship.
sorry. R. Goswami. Appearing for respondent number 10.
10.
And Miss B. Sharma. Appearing for respondent number 1 to 5. Learned counsel for the appellant has submitted that the notice issued to respondent number 8 has not yet returned.
Receive back as yet. I
Not
may be
yet.
allowed to take phase steps, Lordship.
You will take fresh step against 8 and
On-
7 and 8.
8, 7 and 8, yes, Lordship.
8 and 7, and she prays for allowing the appellants to take fresh steps on the respondent number 7 and 8. The prayer is allowed. The appellant shall take fresh steps for issuance of notice on respondent number 7 and 8 by registered post with AD within 3 days from the date of this order, within a week from the date of this order, returnable after 4 weeks. As regards respondent number 9 is concerned, learned counsel for the appellant has submitted that the respondent number 9 did not contested the case before the tribunal also, and his name may be struck out from the appeal, memo of appeal, to which the counsel for other respondent makes no objection. Hence the prayer is allowed. The name of the respondent number be struck out from the memo of appeal. List accordingly after 4 weeks.
Last of lines, Lordship.
Item number 19.
My lord, your lordship may see the order dated 26/6/2024.
Yes.
Now, your lordship can see the page 7 of the judgment, paragraph 3. Madam. My lord, the paragraph 3 reads as such.
Page 7.
Page 7 of the judgment, my lord.
In
The
page
lordship will
7 of
find the
judgment,
memo of
there is
appeal.
nothing.
Lordship got it.
Judgment.
This judgment starts from page 6. I'm drawing your lordship's attention at page 7.
No.
Paragraph 3. Madam.
Memo of appeal, Lordship.
In memo of appeal.
Yes,
Memo of
Lordship.
appeal.
Yes, Lordship.
Yes, page 7. Yes.
At page paragraph 3, my lord.
Yes.
Opposite party number 1, the owner of the vehicle, he was the owner of the vehicle. did not contest the case as he died after the incident. Therefore, the case against this opposite party is heard ex parte. Now, my lord, at the relevant time, it was incumbent upon the learned judge. He should have asked such claimant to implead the legal heir of the person as my lord, party respondent in that case. Now, my lord, he passed it ex parte knowing that the person is dead. And then the passed order against the insurance company. Now, the law is very clear. Insurance company, my lord, is a formal party. If you want to pass any award against the insurance company, the first order will have to be against the owner. Because the insurance company as the indemnifier, they can indemnify only. But the order will have to be passed invariably against the owner, my lord. Now, this is the, my lord, the mistake committed by the learned judge. Another mistake committed by us is we filed an appeal where the dead person has been impleaded as a part. Now, therefore, in the present case, my lord. Therefore, my lord, we could come to know when we took steps but it was to return. Then, my lord, we could realize that he expired at the time of when the proceeding was on in the before the tribunal. Now, so for the execution of the case, now it will be impossible because there is no order against the owner. And the Apex Court has said, if the owner is not a party, no order can be passed against the insurance company. So these order, my lord, the last time
Owner was the party. The case proceeded against him ex parte.
ex parte. Now,
It
ex
is not
parte
a
order.
case where owner is not a party.
No, my lord, ex parte order could not have passed because the learned judge was aware of the fact that the person is no more.
No, that has to be considered in this appeal.
Pardon, my lord?
That issue has to be considered in this appeal.
Yes, yes.
Whether the tribunal was correct or not.
My lord. So that's the issue, my
Or
lord. your
whether
lordship.
the other side is admitting.
No, Lordship. In fact, in present appeal memo, Lordship, they have not taken this plea, Lordship.
No, that's
That plea was not taken, Lordship, in the present appeal memo also, Lordship.
my lord, the question is, this goes to the root of the thing. And your
But it
lordship
has
is-
to be brought before court in your pleadings.
No, my lord, if that the ground is taken, my lord, even now your lordship can pass an order to take that ground, we can take it. These are all technical things, my lord. But then
No, unless you
ultimately,
make a prayer,
Yes,
court would not show
yes,
to pass that.
on oral prayer, Lordship, only on oral.
You
that
have,
can be done even now at this stage also. Because this very question will go to the root of the thing.
and you have to make the legal heirs of the
Executive.
owner,
Yes, yes.
owner party, whether that has been done.
But that will be, yes, if that order is passed, my lord, we can.
No, if that is not necessary, parties are not made party, then
Well-
your appeal may not stand.
Yes.
It is your
that's it.
duty.
My lord, your lordship is very right. That question is there. In that case, my lord, I can do at best, I can file an application to get the leave of the court.
Yes, if you make that submission, I'll allow it.
My lord, I can do that. If my learned friend has taken up that matter and that.
Now, what
issue,
is your prayer?
My prayer is that your lordship can give us a chance so that we can implement them as a party respondent.
And you also want to amend your memo of appeal to bring in
Yes,
some.
that will have to.
Heard Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta. Also heard Ms. P.
Bhattacharya.
Bhattacharya, learned counsel for respondent
Number 1.
Respondent number 1. Learned counsel, senior counsel for the appellant has submitted that it has come to notice of the appellant that during the pendency of the proceeding before the tribunal, the owner had expired and the tribunal proceeded ex parte against him, which according to learned senior counsel was a wrong step taken by the tribunal as the legal heir of the owner ought to have been substituted at that point of time. Now, stop. Learned senior counsel for the appellant has also submitted that as the appellant was unaware of the death of the owner has been made respondent number 2 in this case, and he seeks leave of this court to file an appropriate substitution petition as well as an
That will
amendment.
be an appropriate application. It's not a substitution.
Appropriate application to bring on record the legal heirs of respondent number 2. He also submits that the appellant also intends to amend the memo of appeal to bring some additional ground and seeks leave of this court to file an amendment to take steps for amendment of the memo of appeal. The prayer is allowed. Let this case be listed after 4 weeks. In the meanwhile, the appellant may take steps as indicated here in the book. List
Much
accordingly.
Obliged.
Item number 20.
May I please, Your Lordship? Lordship, in this case, LCR is already received. Service is also complete, Lordship.
Let the matter be fixed for hearing, my lord.
Heard. Miss
SP Das.
SP Das, learned counsel for the
Applicant,
appellant. Also heard Miss
L. Sharma,
L. Sharma, learned counsel for respondent number
1,
1.
insurance, my lord, for the insurance.
1 insurance company. It is submitted at the bar that the service is complete in this case, as well as the case record from concerned tribunal has also been received, and this case is ready for hearing. In view of that fact, registry to release this matter for hearing on an appropriate date.
Obliged, my lord.
Item number 21.
Please, Your Lordship. Lordship, in this case, Lordship, I was asked to take steps by Dusty on Oil India Limited, who were implemented as number 5. Lordship, I failed to do it. I'm given just one opportunity to file the Dusty. And I also serve a copy of a panel advocate, Oil India as a panel advocate for the High Court. Lordship, I'll serve a copy on them.
Heard Mr. R. Goswami, learned counsel for the applicant. This application is condonation for
Yes, Lordship.
applicant who prays for some
And
time-
of the cross
cross
appeal.
who prays for some time for taking steps for issuance of notice
Yes, sir.
on the respondents
By Dusty, sir.
by Dusty mode.
Understood.
The prayer is allowed.
I may also be allowed to serve a copy under council. Oil India.
The petitioner may also serve the copy of the notice as well as the application to the standing counsel of the respondent number
5, Oil India Limited.
to the standing counsel of the respondent Oil India Limited. The prayer is allowed
But, I am appearing in this case, my lord.
for
I am for the appellant, my lord. My lord, here, my lord, they have filed an IA. My submission is that entire case, my lord, may be listed for hearing, my lord. It's a 2014 matter.
no, but this IA is for cross objection.
No, sir, in the meantime, if it is fixed after 2 months, a fixed date is given, in the meantime, I'll process Dusty Service Law, panel or local delimit.
No, but unless their cross objection is admitted, which is barred by limitation according to them, how we can hear both the matters?
Yes, Lord.
Limitation has to be condoned.
Yes, Lord.
So let this matter be listed after
This is
4
tough, Lord, so just-
4 weeks.
Yes.
4
Tough,
weeks to be a date fixed by the list.
Lordship may make it 6 weeks, Lordship. Someone has to serve it there.
6 weeks
Yes, Lord.
to be a date, on a date to be fixed by the list. Today, what is fixed? Only IA or main case is also fixed?
Yes, Lordship.
No, only
This part 2016. Yes. 2016.
this is item number 20.
21.
Where is MSA? Okay, let us first dispose of this.
Yes, Lord.
In cross-exam objection, you are also appearing.
I am for the appellant, main appellant.
Main appellant means who?
Ruma Borwan.
Cross-objection.
Ruma Borwa and her son.
Mr. A.R. Sigdar appears for respondent number 1. Ruma Borwa only or Dilip Borwa also?
Yes, my lord, both.
Appellant number 1 and 2. Appellant / opposite party number 1 and 2 in this case. List accordingly after 6 weeks.
Lovely.
Lordship, in this case, my lord, pleading completed, my lord, regarding condonation of delay, substitution and abatement. My lord, 3, my lord, IA. Matter may be fixed for hearing, my lord, otherwise. And
Hearing, it will go for hearing.
my lord, they file all
Have to dispose
objection
of
already
the
filed.
item. 8 years delay, they have come after 8 years delay. We
And
have got
question
it.
is very interesting, your lordship.
No, what will go for hearing? The IA will go for hearing.
How you may be disposed of.
No,
I
today it is fixed in orders column.
Order.
We will fix it at admission hearing column.
Yes.
And there is an interim order, my lord, that shall be continued. Eventually, my lord, substitution petition have to file from the respondent. They has not filed. And I am helping to bring the record.
This IA 4250 is for?
4250 is my lord, for condonation.
It
Condonation
is
of
my lord,
delay,
8 years delay, 8 years.
maybe.
They are from the same family.
And
who-
IA 4251?
4251, that is substitution of the legal heir. Legal heir.
And 4252?
52, this is my lordship abatement, setting aside the abatement. Because when
These other 2 IAs will come into picture only after condonation of the delay. First IA is allowed.
yes. And question is, my lord, when
may be
respondent
fixed.
dies, demise,
If
We are
honorable court-
fixing the condonation of delay petition for.
A short
adoption.
death may be there. It is already
Heard,
8.
Mr.
Namto.
K. Bhuya. This is item number 23.
analogous.
Heard, Mr. K. In common order. Heard, Mr. K. Bhuya, learned counsel for the applicant. Also heard Mr. A. Alam, learned counsel appearing for respondent number. For all respondents, you are appearing.
Yes. The representing for all.
For the respondents. It is submitted at bar that the pleadings in this case is complete. And the IA number 4250/2020.
4250 and lordship 4251. They file
4251
objection
for-
only in these two I.
4251 is for?
4250 and 4251. 4251 for substitution.
No, substitution question will arise only if delay is condoned.
Oh, no,
Suppose delay is not condoned, then that would become infructuous.
exactly. Wrong.
So only 4250 would be fixed for admission hearing.
And Lordship, so for 4252, it is my lord ultimate my lord matter because of abatement. It's a process. No order against no order I challenge. Because when respondent dies, that they has not placed the record, whether when died.
No, let us first see the condonation petition.
And when they file affidavit, then I come to know
That's the last thing.
that on such date device. Without record, I cannot approach before this court.
May be fixed for admission hearing. When should we fix it?
Sort that next, first week.
First week of August.
And in the meantime, my lord, interim order passed earlier, 29/12 to 2020. Shall be confirmed.
Interim order dated
29/12/2021.
Execution state. Let this case be listed again in the first week of August on a date to be fixed by registry. The interim order shall continue till next day.
Next day. I love this.
Number 24.
May pleasure, Lordship. My lord, in compliance with the order dated 29/5/2024, learned counsel for the respondent number 1 has furnished the correct address of the heirs of the respondent number 2. Only last night, that was received by me from my learned friend. Today he is not present, my lord.
Who is appearing for? You are appearing for appellant.
My lord.
You are appearing for the petitioner.
Respondent number 2, I am for the petitioner. Respondent number
The
2
address has been
died.
furnished to you.
Has died, but I took steps, but notices could not be served because of improper and incorrect addresses. So lastly, an order was passed by this court directing the counsel for the respondent number 1 to furnish the correct address, my lord, because respondent number 1, that order may be looked into. 29/5/2024.
Yes, yes. Now you got the correct address.
That has been furnished to me. I'll have to take steps, my lord. I'll have to take steps again.
Third, Miss B. Chaudhary.
Yes, my lord.
B. Chaudhary, learned counsel for the petitioner, who submits that in pursuant to the order dated 29/5/2024, the respondent number 1 has furnished the correct address and legal representative of respondent number 2 to the learned counsel for the petitioner. Now, what step we will take? For issuance of notice.
Two A, 2B, 2C, my lord.
You have to submit a memo of addresses. Your application has to be corrected by incorporating the correct address of 2A, 2B, 2C.
Lord, I'm sorry, but I am unable to hear you.
In your petition, in your petition, you have not mentioned the proper address of 2A, 2B, and 2C.
You see, now they have furnished, no?
Now they have furnished
Yes,
to you.
now I'll have
Now
to
you
take
have to
those-
rectify. You have to
Rectify.
make amendments. Furnish a memo of parties to the registry so that registry may make necessary corrections in it.
Yes, yes.
Then you take steps for issuance of notice.
Thereafter only.
Okay. In view of the same, learned counsel for the petitioner is requested to submit a memo of parties, namely respondent number 2A, 2B, 2C with correct addresses thereof to the registry of this court. And on receipt of said memo, the registry shall incorporate the correct addresses of respondent number 2A, 2B, and 2C in the application under section 146 of the CPC, read with section 22, read with order 22, rule 12 of the CPC filed by the petitioner. Thereafter, the petitioner shall take steps for issuance of notice on the said opposite parties by registered post with AD within 7 days of such correction, returnable after 4 weeks from the date of this order. List this case after 4 weeks.
Item 25.
Good. My pleasure, Lordship. Lordship, where in this case, Lordship, as per the last order, Lordship, here, Lordship, all the respondents belongs to foreign country, Lordship. Lordship, we kindly peruse the last order, Lordship. As per in the last order, Lordship, the insurance company, the notice has been served to insurance company through the Union of India, Lordship. And Lordship, and also directed to take a stay through registered post, Lordship, in connection with Lordship, petitioner number, respondent number 2 and 3. So, Lordship, already a step has been taken, Lordship.
Now, what is the report?
Lordship, in Lordship report, Lordship, in Lordship, respondent number 2 or 3, Lordship, it is delivered. Item is delivered. And Lordship, respondent number 2, it's not delivered. Lordship, as the Lordship respondent's address belongs to foreign country, Lordship, I have no correct address, Lordship. Lordship, and moreover, Lordship, in this case, Lordship, this case is pending in the trial court is initial stage, Lordship. The accident took place in the year 2012, Lordship. So, Lordship, ultimately, Lordship, insurance company appeared. They filed their written statement. They accepted that within Assam, it's covered our policy. And thereafter, Lordship, due to non-appearance of this party, the
Who
case
is
was
respondent number 2 and 3?
2 and 3, owner and driver, Lordship.
So owner is required.
Lordship, I think Lordship not required. As because insurance company already told everything, Lordship. In the WS, I have annexed this WS, Lordship.
Now, in this case, at least you have to how to take steps for service of notice if the respondent resides in foreign country.
Lordship,
there is provision in the CPC.
Yes, Lordship.
You follow
Lordship,
that provision.
Lordship, kindly see, Lordship, order, Lordship, 22/3/2024. It is reflected, Lordship, as per CPC rule 26. Order 5, rule 26, Lordship. And as well as, Lordship, the our embassy, Lordship, the foreign ministry.
You take steps according to order.
Lordship, already taken, Lordship. Yeah. Lordship, kindly peruse, Lordship, last order. It is reflected, Lordship. The insurance company, Lordship, notice was served through the Union of India, Lordship, duly served. And acknowledgement received also in record, Lordship.
No, insurance company does not reside in foreign country. Insurance company is of this state. Which is the insurance company?
Lordship, here, Lordship, the foreign here is no grantor is there in our India. It's, Lordship, directly, Lordship, in the Bhutan. This stays is Bhutan, Lordship. Lordship, kindly peruse their written statement, Lordship. There in their written statement, it is categorically mentions, Lordship, that this policy within Assam is covered in our policy, Lordship. So that's why, Lordship, here no Indian grantor company is there, Lordship. They directly
And moreover, Lordship, that's issue has been arising before this trial court, Lordship. That's why, Lordship, 2012 to till date, Lordship, notice has not been served upon the owner and driver, Lordship. And that's why case was pending, Lordship. And ultimately, that in trial court, Lordship, several times step has been taken since 2012. Then ultimately, Lordship, the engaged advocate did not appear. That's why, Lordship, case was filed on. And this order is reflected till the case was filed on till the appearance of the part.
Which order you have impugned?
Lordship, kindly come into page 46, Lordship. There, Lordship, ultimately what happened, Lordship? Ultimately what happened, Lordship? Starting page 47, Lordship. Ultimately what happened, when the petitioner's Lordship came into knowledge that their case was filed on, not is going on, Lordship, then he was appeared and filed an petitions, Lordship, for restorations, Lordship. And ultimately, Lordship, that petition has been rejected, Lordship. On the ground, Lordship, that limitation period, Lordship. Though, Lordship, so far my knowledge, Lordship, the limitation period or law of limitation is not applicable, as because in this order, it is categorically mentions, Lordship, that case was filed on till the appearance of the parties, Lordship. So here, when the petitioners came into knowledge that his case is not going on, is filed on or stopped. So then, Lordship, he appeared and filed petitions to restore my case.
Now, what was the order?
Lordship,
your case was filed or dismissed?
It's a filed on, Lord. Kindly come into page 24, Lordship. And last order, Lordship. 14/11/2017. The claimant is absent without any stay. Peruse inter order. The case is filed in the appearance of the claimant, Lordship.
Where are you?
Page 24, Lordship.
24, yes.
Last order,
Claimant
Lordship.
is absent without any states. Now you appeared before the court for restoration of your case.
Yes, Lordship.
That was rejected.
That was rejected.
That cannot be rejected.
Lordship, that's what rejected, Lordship, on the ground that, Lordship, the limitation. Lordship, that's my submission, Lordship. That trial court, the law of limitation, it's not applicable in this case, Lordship. But trial court, Lordship, whimsically, the petition was rejected, Lordship. And Lordship, since 2012, Lordship, that case is still in the first stage, Lordship.
What you have impugned in this case? Only order dated 3/3/2022.
Lordship, on that day, Lordship, it is rejected, Lordship. By this order.
No, what have you challenged?
Lordship, I am challenged that order.
Where is your
11 portion is 50, last case, Lordship.
Now, who has appeared?
Lordship, here in this case, Lordship, the insurance form, though notice was served, and they before this Honorable High Court, Lordship, they did not appear, and accordingly, Lordship, notice has been order is there, Lordship. The notice has been duly served, and Lordship, so far concerns, Lordship, other owner and driver, they did not appear before this trial court as well as this High Court, Lordship. Lordship, those several times, Lordship, notice was issued from this Honorable High Court, Lordship. Initially, first notice was issued, Lordship, in the year 2022, Lordship, but still not appeared, Lordship. So, Lordship, my humble submissions, Lordship, let Lordship, this case may be proceeded before the trial court, directions may be given within time bound, Lordship, as because Lordship, 13 years going past, Lordship, already 13 years done.
No, the direction was to serve the copy of notice on respondent number 1 through Deputy SGI. Whether respondent number 1 notice have been served.
Yes, Lordship, that is on record, Lordship. Kindly, last order, kindly peruse, Lordship. In this last order, it is
Last
repeated.
order means which order?
Lordship is a 13-5 Lordship. Lordship in a Z, in marks is Z Lordship. It's kept into the record Lordship. Marks Z. That acknowledgement of this receiving the notice Lordship.
Now, why it was not delivered? We are holding that against respondent number 3, notice has been duly served.
Yes, sir.
We give one more chance to serve the notice on respondent number 2. Why is the same mode?
Lordship, as because Lordship kindly peruse Lordship Form 54, case number 17, Lordship. Here, Lordship, this order is I have nothing, no more other address, Lordship. Here, see, Lordship, I have here, Lordship, kindly see that.
But how will you do if they don't appear before the
Lordship? That's why Lordship presumption may be drawn, Lordship, as per section 27 of the General Clause Act, Lordship. As because Lordship, whatever address has been given by the police, this is accident information report, Lordship, case 17. Here it is mentions the address, Lordship. Just Thimpu. His address is Thimpu. Lordship, it's not possible, Lordship, to sub. If Lordship is one again, we sub this sub Lordship, then the same. Here it mentions only Thimpu, Lordship. Address is Thimpu, but this I have no other options to collect his address, Lordship. That's why, Lordship, section 27, Lordship, of General Clause Act, Lordship, presumptions may be drawn, Lordship.
No, presumption can be drawn if there are no material before the court. Now you have shown a material which shows that it is not delivered. Then presumption cannot be drawn that it has been delivered. You have produced before the court a document of Postal Department which shows that it has not been delivered. Now, against that, no presumption may be drawn.
Lordship, in this case, Lordship, the foreign country is there. So, respondent belongs to foreign country, Lordship.
That his presence.
Lordship, I am submitting, Lordship, that AD card will not come there. So far, I inquired this matter, Lordship, on visiting the Meghdut Bhavan. Lordship, that AD card will not come.
We'll hear your matter without that party.
Lordship, then Lordship, another option, Lordship, my submission is, Lordship, so for sections 20, rules 26 is deals, Lordship, CPCs, that Union of India, Lordship, is the best, Lordship, to serve the notice, Lordship. Otherwise, Lordship, even moreover, Lordship, in last order, Lordship, it's also reflected that there is expenses is so much high. So that's why claimant or petitioner is not in positions to bear their expenses, Lordship. So that's why, Lordship, my humble submissions, Lordship, Union of India will be served, Lordship, through consular, Lordship. And Lordship, so far, respondent number 1, that in his first company, that notice was served by the consular, Lordship.
No, the question before this court is, it was filed, a case was filed.
Yes.
You went for restoration of a filed case. Then why the necessity of limitation is,
Lordship, that's
question of limitation is not
yes,
there.
not applicable, Lordship.
We are heard Mr. What is your name? I Hawk.
Yes, Lord.
I have learned counsel for petitioner. Also heard
For Union of India, madam.
Mr.
SK meeting.
S.K. Medhi, learned counsel appearing from
Application level Bhutan also.
Union of India.
Union of India.
Union of India is not a party.
Not parties.
It appears from
Verified.
record that by order dated 13/5/2024. This court held that service upon respondent number 1 is deemed to be complete and directed the respondent to take fresh steps for issuance of notice on respondent number 2 and 3 by way of speed post. The petitioner has accordingly taken steps, and learned counsel for the petitioner has produced 2 track consignment report which are marked as X and Y respectively, and which are made part of the record, which shows that the notices sent to respondent number 3 has been delivered on 5/7/2024. However, notices sent to respondent number 2 is not shown to be not delivered. It appears from record that the petitioner in this revision petition has assailed the order dated
3/3/2022.
3/3/2022 passed by
Additional district and session judge to Kamrup Metro.
done an additional district in Session Judge Kamrup Metro, whereby the said court refused to restore the MSC case number 2235/2023, which was earlier filed on
Lordship 14/11/2017.
on
14. 14.
11/2017. Considering the nature of matter to be considered in this application, and also considering the fact that the case, that the MSC case number 22535/2013 has been pending, is pending before the Court of Learned.
Additional district and session judge.
Additional district and session judge number 2 Kamrup Metro for last more than 10 years.
12. Going. 12.
More than 12 years. And now it is 12 years, it will be 10 years,
11 years.
more than 10 years. And the nature of matter to be considered in this case is such that same may be considered even in absence of respondent number 2 also, as the legality of order dated 3/3/2022 would have to be considered in this case. Hence, moreover, in Form 54, available on record in form 54.
Form number 54, Lord.
Form number 54 available in the record of the MSC case number 2235/2013. The address of the respondent number 2 is shown to be is
Mr. Kasi, Lordship.
is not a detailed address. Hence, considering the facts and circumstances of this case, notice on respondent number 2 is waived, and let this matter be fixed for admission hearing on give it date.
On 23, Lord.
On 23/7/2023.
Union
Union of India is not a party.
Respondent 4. Already, Lordship.
You have made a party.
Yes, Lordship. Respondent 4.
Why?
Lordship, yes, because Lordship, when Lordship initially notice has gone, but not served.
For serving the notice.
Yes, sir. Only for serving.
Then in the meanwhile, you may take steps.
Already there, Union of India has been served a notice to the insurance company, Lordship. They already served by insurance, Union of India, Lordship.
Okay, we'll see if it is necessary. We'll
Yes, sir.
let this case be listed on 23/7.
Yes, sir. Highly appraised. Item number 27.
Fair resolution.
There are 3 interlocutory applications.
My lord, your lordship, kindly take up the miss case number 49.
Miss case 49. Okay.
Miss case 49.
What is this?
My lord, the appeal was initially filed. That appeal was dismissed. Dismissed for
Second
non-
appeal.
My lord,
Second appeal was dismissed.
second appeal was dismissed for non-prosecution.
Non-prosecution.
Yes. The ground we have stated in paragraph number 3.
What is Order 41 Rule 19?
Order
Readmission.
Readmission.
Readmission of the case. Let us see this. Okay. What is the requirement? If you are that sufficient cause. No.
Yes, the sufficient cause we have stated in paragraph number 3. But what happened is this.
Whether
we said-
respondents have been not, you are appearing.
Yes, sir.
You have any objection?
No, Lordship.
No objection. Let us restore it.
Only thing is, your Lordship, Rule 19, Order 41, your Lordship. It says that it has to be as per terms, certain terms of cost or otherwise. I'm not praying for a cost here, your Lordship, but a term that it may be listed for final disposal at an early stage. That may be.
Whether substantial question of law was framed.
It was framed, your Lordship.
It was, the appeal was admitted. Mr. B.R. Day, he was the advocate for the appellant, he died. His junior also died. Therefore, the appeal was dismissed.
Lordship. So my humble submission is it may be readmitted on the same substantial question of law that was framed on 10/11/2014.
No, it will remain same.
Yes.
It will be
It
same.
is only a
It
case
is
of
a readmission.
Readmission. The substantial question of law was framed on 10/11/2014.
That will remain, my lord.
That will remain.
And only prayer is that it may be fixed expeditiously for hearing. 2014 matter. your Lordship.
Mr. A.C. Datta. Oh, sorry. A.C. Sharma, learned senior counsel assisted by Mr.
G. Bharadwaj.
G. Bharadwaj. Also heard Mr.
Vijay Mukherjee.
Vijay Mukherjee, learned counsel appearing for the respondents. This application under Order 41, Rule 19 of the Code of Civil Procedure has been filed by the applicant for restoration of
Readmission.
for readmission of RSA number 273/2014, which was dismissed by this court for non-prosecution on 28/3/2022. Where you have stated reasons.
Paragraph number 3, page 5.
Then senior counsel for the applicant has submitted that the reasons for failure on the part of the appellants to appear before the court on 28/3/2022 has been sufficiently explained in paragraph number 3 of the application under Order 41, Rule 19 filed by the applicants. I have gone through the said reasons mentioned by the applicants. And it appears that the earlier conducting counsel for the appellant, Mr. B.R. Dale, within the senior advocate, and Mr. Pranoy Sen, who was assisting the learned senior counsel, both expired during the pendency of the second appeal, regular second appeal number 273/14, due to which there was a communication gap between the appellants. With the appellants, so that they could not engage a new set of counsel, and which caused the default on the day when the second appeal was dismissed. Learned counsel for the respondent who has appeared in this case has submitted that, considering the reasons shown by the applicant, he does not have any objection on readmission of the appeal. He has also fairly submitted that he is also not pressing for any cost and has only prayed for expeditious disposal of the pending second appeal, as same has been pending since the year 2014. Stop. Considering the submissions made by learned senior counsel as well as learned counsel for the respondent, as well as the cause shown in paragraph number 3 of the petition, this court is of considered opinion that the appellant has shown sufficient cause for which the appellant was prevented from appearing before the court when the appeal was called on for hearing on 28/2/2022. Hence, stop for the reasons aforesaid. This interlocutory application. Now, this miscase is allowed and regular second appeal number 273/14 is readmitted. The registry to list the regular second appeal 273/14 for hearing on a date. When do you want?
Next month, Your Lordship. August.
After 4 weeks, on a date to be fixed by the registry.
Already, I have also another application, IA number 3372, 3370 and 3371. These applications are
3370 maybe. 3370.
3370. Respondent number 1 died.
This case is accordingly discussed. 3370.
Yes, ma'am. The respondent number 1 died. And we made an application for substitution of her heirs and legal reviews. And my learned friend has already appeared.
Appeared for all the respondents.
Legal yes.
Therefore, all the 3 applications may be allowed.
All the 3 applications are for substitution.
Substitution, abatement, and setting aside.
And for delay, setting aside.
Now, whether this has to be considered after it is restored to file, because now in the CIS, it has been shown as disposed of. The main appeal has been shown as disposed of. After today's order, it will be restored. Then when it is listed again for the hearing, only then these applications may be considered. Because now there is no, this we will consider when the matter is listed.
Lordship,
Because he has appeared.
Lordship, in that case, if other than keeping it for 4 weeks, Your Lordship, it may be listed for orders again after 2 weeks for this.
In this application for substitution, condonation of delay and setting aside, my learned friend has no decision because
No, but now there is no case.
Yes, Your
Oh, I see.
Because this order has to be communicated to the filing section. They will restore it. And in connection with that restored RSA, these application will be considered. We may fix it.
It will be
Instead of
listed after 2 weeks.
In the
Listed?
in earlier case, 4 weeks assignment, it may be listed after 2 weeks.
For orders.
For orders.
For orders, instead of hearing, for orders. Then we will consider these 3.
Item number 28.
Chairman, according to last order, my lord, dated 5/6/2024, my lord, the appeal is admitted and substantial question of law is framed, my lord.
We have received the copy of the RSA, but the I has not been received by us.
My lord, it was served, my lord, earlier, my lord. IA is for stay, my lord.
But it is a money decree.
Execution is there.
Execution is there, but
It's
it's
there on next that is fixed on 30th of July, my lord. There's notice issued for
but it
depositing
is a
the
money
money.
degree.
Yes. This last date.
But
It's a money degree, so the security has to be deposited for.
oh yes.
My lord, only 2,74,000.
But as per order
So, my lord,
41,
this, immediately
Yes,
come.
order 41 rule.
rule 5.
Order 41 rule 5, we may impose what it says.
41 rule 5. 41 rule 5. Sub-rule 3, Your Honor. The security has to be given by the applicant for the due performance of such decree or order as may ultimately be binding upon him. And sub-rule
You are
5 says,
Union of India,
Yes, yes.
give some security.
Immediately, my lord, on
No,
30th
government
of
need
July,
not
this
to give
matter is
security.
fixed, my lord.
and to this, that isn't served to us today, we'll file our objection also.
No, there is some
My lord,
provision
it was,
somewhere.
it was served, my lord, it was listed on February itself, my lord.
Okay.
February itself, there's the orderment. February,
No, we are staying the execution.
and there is,
And regarding security, government, I think need not to order for, wait, there is some provision.
Yes, sir. Order 41 rule 5.
Rule
5.
5. No, some provision requiring government not to pay.
no, the application has to be made
That
without
has not
reason.
been-
Well, before 30th, my lord, this next date for execution, but before 30th, this matter will be heard, my lord, and in the meantime.
Till 30th, will not proceed with the execution. That may be. But to the, I will file our objection.
And it was, my lord, February itself, I was filed, my lord, it was listed, and the order was also passed, my lord, to come along with this matter. I go to this, I go to this.
Do you want to file an objection?
Yes, we'll file an objection.
Till you file objection, we will just stay.
Yes,
in
yes.
interim. Now, Mr. S. K. Negi, Senate counsel for the applicant. Also have Mr.
J. Das.
J. Das, and counsel for the respondent, both the respondents.
Both the respondents.
Both the respondents. This application under this application has been filed by the applicant / appellant for stay of impugned judgment and order dated impugned judgment decree dated 10/2/2005 passed by the civil judge Jorhat in 41 flat. The counsel for the applicant has submitted that the applicant has preferred the connected appeal, which has been registered as RSN 205/2015, wherein he has assailed the judgment and dated 7/8/2023 passed by the district judge Jorhat in appeal number 3/2022. It is also submitted that by order dated 8/6/2024 passed by this court in connected second appeal. The substantial question of law in the second appeal has been framed and the appeal has been admitted for hearing. It is further submitted that the respondents have in the meanwhile preferred an execution proceeding before the Court of London.
My lord, this is 4 of, my lord, I've given. Jorhat, execution, my lord, before that, civil judge senior division, Jorhat, money execution of 4 of 2022.
Which has been registered as money execution number 4 of 2012. Before the Court of Civil Judge Senior Division, Jorhat. When counsel for the opposite party respondent has submitted that they may be allowed to, that he may be allowed to file a written objection against the prayer for application for stay of the appeal. stay of the execution of the impugned judgment.
Your Honor, in the meantime, he may be directed to furnish the 50% of the secured decretal amount. As it is a money decree.
No, that after final stay,
Yes, my lord.
we are giving interim stay
Interim.
for
But before the stay of the execution, as per order 41, rule 5, that 50% has to be given as a security. Sub-rule 5, notwithstanding anything containing in the foregoing sub-rule, where the applicant fails to make the deposit or furnish of the security specified in the sub-rule 3 of rule 1, the court shall not make an order staying the execution of the decree.
Applicant fails to make a deposit furnish security.
what is there in sub-rule?
No order of stay of execution shall be made under sub-rule 1 or sub-rule 2 unless the court makes if it's satisfied. There has to be satisfaction that the serious.
That is with regard to final stay.
Yes.
Because A, B, C has to be.
The applicant has to make.
When will you file objection?
Before the next date, you know.
When?
2 weeks may be granted. So
for 2 weeks, we are granting interim stay.
Execution, my lord, cases fixed on 30th
We are
July.
putting halt on that.
on it may be reflected that we will not proceed with the execution. Stay may not be granted. We will not proceed with the execution on that day. On 30th, we will not proceed with the execution.
The matter remains same.
Same. But
The counsel for the petition, respondent is allowed to file written objection against the prayer of stay made by the applicant. However, as the appeal in the as the second appeal preferred by the applicant has been admitted and the substantial question of law has already been framed, and still the next day, that is, give a date.
uh, 26.
26/7/2024.
26, I will be out.
Give a date.
Day after, my lord,
31st.
August, my lord, August.
Give a date.
2nd August. my lord.
2nd August.
Yes.
2024. The in interim till 2nd August 2024. The operation of money execution case number 4 of 2022 pending before the Court of Learned Civil Justice Senior Division Jorhat shall be stayed. Is this case again on?
My lord, yes, in main case, as the appeal is executed, my effort of the lower court is more required this main case. My
Yes, I told you about that. The main case. Learned counsel for both the parties are present. It appears that this appeal was admitted by this court on 5/6/2024. However, the records of money appeal number 3. Records of this case number 46/2022 in money appeal number 3 of 2023.
And money suit, my lord, 41 of 2018. Money, it was expiry order was passed, my lord, money suit.
As well as money suit number 41/2018 has not been called for. No money suit, whether it is required.
Because, my lord, the main, my lord, the appeal was, my lord, dismissed on a delay ground, my lord, that part, my lord. So, my lord, mainly money suit was, this was expiry order was passed in money suit, my lord. So, money suit will be required.
Equal for from the court of, from the concerned courts. The registry to issue requisition for the aforesaid case records. Let this matter be listed again on 1st of August.
Second of August. Highly applies.
Highly applies.
Item number 25.
May please your lordship. In this case, what happened? The appeal was disposed of on the ground of eviction for non-substituting the legal heirs of deceased respondent number 2. Now we have filed three applications for setting aside of abatement order dated passed in the appeal along with other 2 applications. Notices steps have been taken on several occasions. Now, as per last order, if your lordship kindly peruse the office note dated 15/7/2024, your lordship. All are served except respondent number 5 and 7, your lordship.
Seven is deceased.
Yes.
5.
5, we need to take proper instruction whether his address is changed, and with regard to respondent number 7, the legal heirs need to find out your lordship.
Take steps.
Lordship.
You take steps accordingly.
Steps were already been taken.
No,
We need to take.
You take instructions regarding
Yes,
proper
sir.
address of respondent number 5. Respondent number 5. And then you take instructions regarding legal heirs of respondent number 7. In view of the report, you take necessary steps. Our Miss S.D. Dasgupta.
S. Dasgupta.
S. Dasgupta, learned counsel for the applicant. It appears from the office note dated 15/7/2024 that the service report of the notices issued to respondent number 1, 3, 5, 6, and 7 have been received back by the registry of this court. And it appears that the respondent number 1 refused to accept the notice, and the notice was duly served by hanging the same on the front wall of the house of the respondent. As regards respondent number 3, the notice 3 and 6, the notice have been duly served. I have perused the reports. Report of service available at flag X in the report. Considering the report of service, the notices issued to respondent number 1, 3, and 5 are held to be duly served. As regards respondent number 5 is concerned, ED card has received them. What is the name of respondent number 5?
Mohammed Yahya Chaudhary.
It appears that though the process server has furnished a report that the said respondent was not found in the given address. However, the ED card issued along with the notice sent through registered post by the appellant has been received back with signatures of the addressee on the AD card. In view of this same, what will you do?
That is to be considered as SART.
In view of the same, the notices on respondent number 5 is also deemed to be duly served. The petition, the report against respondent number 7 shows that the respondent number 7 has already expired. Learned counsel for the petitioner applicant has submitted that the applicant may be given some time. No, she may be given some time to seek necessary instructions regarding the heirs of the respondent number 5 and accordingly take appropriate steps thereafter. The prayer of the petition, learned counsel is allowed. Let this case be listed again after 4 weeks. In the meanwhile, the petitioner, the applicant may seek. In the meanwhile, learned counsel for the applicant may take necessary instructions regarding the legal heirs of respondent number 7 and take steps accordingly. Listed.
Item number 30.
The petitioner is filed in matrimonial appeal against the key passed by the Lanet district judge Udalguri, resulting the marriage between the petitioner and his wife on the basis of the petition filed by the petitioner husband, my lord, that she has been tortured, mentally tortured by the wife and the deserted her. But both the grounds have been stated, both the grounds are proved by the petitioner by establishing producing evidence. So the Lanet trial court has liquid the suit, resulting the marriage, holding that the torture, mental torture and desertion projected by the husband against the wife has been proved. But he has granted alimony of rupees 20 lakhs, madam. Again, the alimony portion will come, madam. That 20 lakhs alimony was granted without assessing the income of the deceased mother or income that
No,
petitioner.
why it has come in orders column today?
My lord, IA has been
yeah,
listed. There is an IA for
yeah.
stay, an interim stay has been granted till filing objection, my lord. We have filed objection. It was still returnable date, my lord. It was.
I have filed for staying the execution of the decree, that is the realization of the alimony, disposal of the equity, madam.
My lord, we have filed on 3/5/2024.
Their objection is that the petitioner is earning the lakhs of rupees per month, he can, but no documents have been filed. But regarding the income that the petitioner, we have filed the documents by our additional affidavit.
Stay.
My lord.
If we vacate this stay, the appeal
Petitioner
will become
is filed on
infructuous.
10/6.
Lord. Yes, so my lord, LCR has been received, my lord. I'll pray, my lord, let the main appeal be taken up.
And the stay would continue.
Stay, my lord, I have objection. Stay was still, my lord, returnable date. And in between there was, the case was last listed on 27/5/2024. But this order has not been continued, my lord.
It may be allowed
It
to
was-
continue to dispose of the appeal because the LCR has already received notices served. The appeal may be heard in near future, madam.
This stay was till
So still
12/1/2024, madam.
Thereafter, there is no stay.
Not continued, madam. It is not renewed.
Whether you filed any execution case,
Not yet, madam.
then what has been stayed?
That's why, my lord. There is still chance to file execution case.
Now, what do you suggest?
My lord, as the LCR has come, my lord, a date may be fixed, my lord. My lord may.
When we can hear, when?
First week of August.
First to August, main appeal hearing, my lord. It may be after 15 August, my lord. Till then, interim order is continuing.
learned counsel for the, not learned counsel for the applicant as well as learned counsel for the respondent. Both the counsels made submissions that the main appeal is ready for hearing. And therefore, the said appeal may be expeditiously heard by fixing a date of hearing. And in view of said submission, the interim order granted on 4/12/2023 shall continue till further orders.
Already date may fix for hearing.
Till
fixed.
Till next date.
Till next date of the hearing.
Other question.
Not Mr. K. Sharma, learned counsel for the appellant, as well as Mr. What is your name?
M. Ali.
M. Khan.
Ali.
M. Ali, learned counsel for the respondent. The reports of title suit B case number 26/2016, which was requisitioned in case of this appeal, has been received by the registry. The counsel for both the sides have submitted that a short date of hearing may be fixed as there is an interim stay granted regarding execution of the decree as regards payment of permanent alimony of 20 lakhs in pursuant to the judgment in decree passed in title should be case number 26/2016 to the respondent. In view of the submissions made by the counsel for the parties, let this case be listed for hearing in the next week in the week commencing after.
Or they kindly date may fix. The date is
No, date.
20 of August. It's a hearing day. 20 or 22.
On 20th August. 20th. 20 August. 20. List accordingly.
Publish.
Publish.
My lord, actually, technically, he should have filed an application because on the last occasion, this interim order that was not, my lord, renewed. That even they have not prayed for.
It is in continue.
I leave it to your lord.
Till the filing of this, my additional application only.
Till next
It
date.
was not this.
Till next date, it was 12/1, 12th of.
We'll consider on 20 August.
In the IA, my lord, lordship has already stated.
Yes, the case is not.
In IA, it will continue till 20 August. Until further, instead of until further August, until 20th of August.
Publish.
Your Lordship, in this case, the petition is already admitted and the LPI is also received. My lord may kindly take up the matter for hearing.
My lord, it's a landlord tenancy matter and it's a matter of 2013. That suit is of 2013, concurrent finding by the trial court as well as the first appellate court. My lord, may I pray for early hearing? My lord?
For that you have to file an.
My lord?
For that you have to file an interlocutory appeal. There may be other.
This appeal has already been admitted and there is a stay operating till today. LCR has been received.
In the second week of August to be.
My lord.
Miss, what is her name?
K. Sharma.
K. Sharma, learned counsel for the petitioner also heard Mr. Aid or learned counsel for the respondent. It is submitted at bar that this case is ready for hearing and it may be fixed for hearing on an early date, considering the fact that a stay is in operation. Considering the submissions made by learned counsel, the registry is directed to list this case for hearing on a date in the second week of August to be fixed by it.
Production interim order.
The interim order shall continue till next day.
Obliged, fine.
Item 32.
May please, Your Lordship. Your Lordship may peruse the last order of this honorable court dated 24/6/2024. 24/6, Your Lordship.
Yes.
Yes, sir. Today, Lordship, I am praying for that is interim order for staying that proceeding in the learned court below. That is the learned principal just family court, Nalbari, Your Lordship. Actually, what happened, both the petitioner and the respondent here, her husband, they are presently posted at the CISF unit ONGC, ONGC Jorhat, Your Lordship. So they come within the jurisdiction of that learned district and session just Jorhat, Your Lordship. Instead of filing that petition,
You
he
are
has moved
husband
here.
or wife?
I'm for the wife here.
You are praying for transfer of the
Yes,
case
yes, my
from
lord. From here, from Nalbari to the Jorhat.
Jorhat.
Yes, my lord. That is my prayer.
Husband has filed.
Husband has filed that matrimonial suit before the learned principal just family court Nalbari, Your Lordship. Lordship will find it Annexure C, page 22. That is a notice being issued by that family court. So that proceeding is accepted. That is for the with a prayer for transfer of that proceeding to the learned district and session judge Jorhat, Your Lordship. That is a prayer. And the distance is also, it is about 337 kilometers from Jorhat to Nalbari, Your Lordship. And both are, they are in the same unit at Jorhat. That is CSF unit ONGC Jorhat, Your Lordship. So it would be far convenient for both the parties. If that case is transferred from Nalbari to Jorhat, Your Lordship. That is a prayer sector. And for the interim prayer, my
Fix it for hearing.
Lordship may fix it for hearing, but in the meantime, that proceeding is.
Heard Mr.
Deborah, Your Lordship.
Deborah, learned counsel for the petitioner, who submits that that order dated 24/6/2024 reflects.
Yes.
That the notice issued to the respondent has been served by delivering the same has been served as same has been received by the brother of the respondent. And accordingly, this court held the notice to the respondent to be duly served. Today, nobody has appeared for the respondent. However, learned counsel for the petitioner has submitted that the matrimonial suit within bracket D 36/2024, which is pending before the court of learned
Principal Judge
Family Court Nalbari, may be what was the name? Last line. That the proceedings of proceedings of matrimonial suit number E36, which is pending before, may be stayed.
Yes, ma'am.
May be stayed during the pendency of the instant transfer petition. Now, till disposal of the transfer petition. As this case is fixed for in orders column today, and as same is ready for hearing, let this case be fixed for admission hearing on after 2 weeks.
Yes.
From the date of this order, on a date to be fixed by the registry. In the meanwhile, further proceedings of FC matrimonial suit within bracket D 36/2024 pending in the court of learned principal judge, family court, Nalbari,
Lordship, within bracket D.
within bracket D,
Yes, ma'am.
Nalbari shall be stayed till the next date.
Matsu.
My lord, item number 46, my lord, there was an interim order in operation. So this order may be allowed to continue. And on the other hand, my lord, so far as the respondent number 1 is concerned, notice served, my lord, notice returned unserved. So, my lord, I have an alternative, my lord, address, so I may be allowed to take steps on respondent number 1 in the alternative address as available on records. An interim order which was passed on 24/5 of 2023 may be allowed to continue.
Others orders I am not passing. No, still we have some time left.
Otherwise, my lord, stay will go, my lord. Today, up to, my lord, next date, interim order was in operation till next date. So it has to be.
No. I am wondering why 46 cropped up. We,
What way? Order to continue.
no, we will continue till 4:45.
As your lordship, please, my lord. I think, my lord, lordship is rising. That's why I made a mention.
No, I am not rising.
My lord, all right.
Because court timing is still 4:45
All right.
or 4:30.
4:30.
No,
4:40. All
it
right.
is 4:45. I'll take up your matter.
My lord.
In the meanwhile, we may take
My lord.
1 or 2 cases.
Obliged.
Next, lordship, kindly place the last order, man.
Yes.
Lordship, in terms of the last order, I am supposed to file Lordship affidavit, the objection, but it could not be filed because due to not getting of certain documents, Lordship. So, Lordship, therefore, I am praying for 2 more weeks' time, Lordship, to enable me to file affidavit, Lordship.
So last order, interim was supposed to be considered since there is no stay operating, my lord.
Next date before trial court is 16 August, Lordship.
Your husband or wife?
His
I am
husband.
the husband, Lordship.
I am the wife, my lord.
Where the case is pending?
It is pending in Tinsukia, Lordship, and they are seeking transfer to Dibrugarh.
Where the wife stays?
Wife, Lordship, Dibrugarh.
Till you file your affidavit, it will be said.
But Lordship, the next date before trial court is 16 August. It can be fixed before that, Lordship. I will file affidavit and it can be disposed of, Lordship.
The last order was passed on 26/6, my lord. Sufficient time was granted, my lord.
That was the first
No,
occasion, Lordship.
we may fix this.
My lord.
Before the date fixed before trial court.
Heard Mr. A.K. Gupta, learned counsel for the petitioner. Also heard Mr. N. Hassan, learned counsel for the respondent, who submits that though he prayed for some time for filing his written objection on 26/6/2024. However, he could not collect certain documents for which some more time is required to file his affidavit on opposition, file his written objection. On the other hand, learned counsel for the petitioner submits that on 26/6/2024, this court had made an observation that today, that is on 17/7/2024, the prayer for interim relief would be considered. I have considered the submissions made by learned counsel for the parties. Mr. Ain Hassan, learned counsel for the sole respondent who has sought for some more time, is granted another 2 weeks time for filing written objections. However, in the meanwhile, the further proceeding of
Page 28, my lord.
further proceeding of
Title should M number.
Title should M number 1 of the
title suit within bracket M number 1 of 24 pending before the Court of Learned Civil Justice Junior Division, Tinsukia. Civil Judge Junior Division.
My lord.
Lordship.
Civil Judge Junior Division, Tinsukia, Assam. Be stayed, in interim till next date.
My lord.
The registry to fix this case after 2 weeks from the date of this order.
Obligation.
Yeah, please, Lord. So far, office note dated 15/7, it may be seen, Lordship. Registered steps were taken. Registered steps were taken. Lordship.
We'll await.
Yes, let us wait. For next date may be fixed
Yeah,
after 1
Lord,
month.
I'm appearing for respondent number 1 to 4, 1, 2, 3, and 4.
1, 2,
3 and 4.
So only 5 is remaining.
Yeah, yeah.
Respondent number 1, 2, 3, and 4. We have entered the evidence by finding the Wakalatnama.
Yes, filed the wakalat.
But their names does not appear.
Our name has been in the cause list, reflected in the cause
From
list.
the office note dated 15/7/2024, it appears that neither ID card nor unserved notice in respect of respondent number 1 to 5 has been received back by the registry. However, Mr.
S.A. Bakhtiar.
S.A. Bakhtiar has appeared for respondent number 1, 2, 3, and 4.
Yes.
And has submitted that he has already filed
The
the
Wakalatnama.
wakalatnama before the
Our name has not been reflected in the cause list. Let the names be reflected in the cause list.
before the
1 to
registry.
4 or 1 to 5.
1 to 4, 1 to 3, and 4.
The registry to reflect the name of the Mr. S.A. Bakhtiar
And N. Alam.
and N. Alam as counsel for respondent number 1, 2, 3, and 4 against this case. As regards respondent number 5 is concerned, await service report. Let this case be listed again.
Lordship, so for 6 and 7 is concerned, State Council has already received their copies. In the last order, it reflects like it. So for the 6 and 7 is concerned,
Who is appearing for state?
the copy has already been served to them.
State council.
So 6 and 7,
Nobody
Is it-
appeals
official respondent,
for
State council.
respondent number 6.
copy is already
List this matter after 4 weeks.
after 4 weeks. Yes.
4 weeks.
Douglas.
Lots of applicants steps on respondent 2, 3, and 4. But the service is awaited as per the office note dated 15/7.
One is appearing.
My lord, I am appearing for respondent number
Heard
1.
Mr. G. Khandelia, Bennett.
Our fault.
Heard Mr.
Our fault.
R. Paul, Bennett counsel for the appellant. Also heard Mr. D. K. Sen, who is appearing for respondent number 1. As regards respondent number 2, 3, and 4, neither the AD card nor this unserved notice have been received by the registry. Await further. Stop. List this case after.
My lord, I have not received the copy of the memo of
List this
appeal.
case after 4 weeks.
I will
You
serve it
furnish.
today.
I am not reflecting it in order. He will furnish. You furnish it.
But-
The counsel for appellant is requested to furnish a memo of appeal along with the annexures to the learned counsel for the respondent number 1.
Obliged.
Earlier.
May I please, Your Lordship? Lordship, on the last occasion, we were directed to take steps by registered post with AD as well as Dusty was permitted, Your Lordship. Now, Your Lordship, Dusty is already complete and we have already filed the Dusty compliance affidavit, but it is not on record, Your Lordship. That may kindly be called for, and the matter may kindly be fixed on Monday, Your Lordship.
Heard Mr. A.
A.
Khan, learned counsel for the petitioner, who submits that in pursuant to the directions of this court by order dated 21/6/2024, the petitioner has taken steps for service of notice on the respondent. How many respondents are there?
3 respondents.
Respondents through Dusty mode, and the Dusty service has been completed, and the petitioner has also filed an affidavit of compliance of the service of notice through Dusty mode. However, the said affidavit is not on record. The registry is directed to place the affidavit of compliance filed by the petitioner with the case record and list this case again on 22nd.
Obliged, Your Lordship.
May I please, Your Lordship? My Lord, there is a delay of 250 days in filing this first appeal against order. My Lord, the title suit Matrimonial was decreed against the petitioner. She filed an application under Order 9, Rule 30 for setting aside that ex parte decree. My Lord, that was dismissed because the counsel appearing for the petitioner in the learned court below did not appear because of want of vakalatna. It's primarily because the petitioner could not maintain.
Has come in orders from today.
Because this is an application for condonation of delay. Until unless the delay is condoned, the matter cannot be listed for admission hearing.
You have objections?
Yes, my lord. There's some technical issues, my lord, which I'd like to point out for my lord.
Then what? Today we are done with 10th.
Lordship will kindly give a fixed date.
Fixed date. We are, when do you want?
As early as possible, Lordship.
We'll fix this IA in admission hearing column.
Lordship,
Because if
condonation of,
suppose this IA is rejected, assuming,
yes,
then the case goes,
the appeal goes,
yes.
yes.
So this IA has to be heard in the,
But generally condonation matters, they are disposed of at admission, at order stage.
okay.
That is the practice here.
It may be fixed for admission, my lord.
No, if that is the practice.
I leave it to my lord.
Yeah. The first, the delay has to be
This
condoned.
matter could heard Mr.
P. Bhom.
P. Bhomik, learned counsel for the applicant. Also heard Mr.
R. Senswar.
R. Senswar, learned counsel for the respondent. How many respondents?
1 million.
Sole respondent.
1 month.
This matter could not be heard due to paucity of time. Let this matter be listed again on
Any date, my lord.
suggested date.
Next week, sometime next week. When is it a hearing day?
It's Monday,
Let it be on 23rd.
23rd, my lord.
23rd.
Obliged, Lord.
Yes, Mr. Pastor.
My lord, I am appearing the next item 38.
No, we are not taking up that.
My lord, only thing is this, my lord, in a second appeal, I am for the respondent. In a concurrent finding of facts, the appellant came before your lordship. And my lord, they have obtained a status quo order. I have filed an application under Order 39, Rule 4. So can it be taken up on 24th? 23rd or 24th?
24th.
24.
The interim order will be extended.
Item number
38.
38. Let this matter be listed again on 24/7. The interim order shall continue.
Okay.
Yes, Mr. Professor.
Lordship, extend the interim order.
Interim order shall continue.
No, item number 43 I have mentioned.
Yes, 43.
For the next payment.
46, what is the matter?
The lordship, 43.
46.
46 months. So in this case, my lord, there was an interim order, which was.
We are, the matter will be shown as leftover. The interim order shall continue.
Continue. And my lord, so far the my lord, response number one, I may be.
Others without perusing record, I will not pass it. So 46, the matter could not be heard due to paucity of time. The interim order shall continue till next day.
Yes, interim order dated 24/5/2023.
Interim order dated 24/5/2023 shall continue till next.
Made with your lordship. My lord, I am mentioning item number 41. It is listed for hearing. I am the respondent, my lord, plaintiff. Title sheet was filed by me and it has been decreed in my favor. And my lord, the respondent was a tenant there. He has been directed to be evicted under ground of defaulter and bona fide requirement. Now, because of pendency of this CRP for last 6 years, I am not being able to.
6 years.
Yes, 18 case, my lord. So, matter may be kindly fix a date, my lord.
You suggested it.
Lordship, first, on 1st of August, my lord.
Other side is there.
I'm there.
Heard Mr.
J. Patwari, my lord.
J.
For the respondent.
Patwari for. Heard Mr. R.S. Mishra for the petitioner. Also heard Mr. J. Patwari for the respondent. With the paucity of time, this matter could not be heard. Yet this matter will be listed again on 1st of August.
Deeply.
Resolution. Item number 47, there is interim order, it may be complete.
Item number 47, paucity of time could not be taken up. Interim shall continue.
Your lordship, item number 43. Stay order is there.
Item number 43 also. Paucity of time, stay order will continue.
My lord, I have item number 39. It's a very short matter, my lord, the only notice will go. Because there was a petition for condemnation of delay. In
CRP, I only.
IA 1393.
Item number 39.
39.
A.K. Sharma, London. A.C. Sharma, London. Senior counsel assisted by Mr. G.
This is A.K. Sharma.
Assisted by Mr. A.K. Sharma. Issue notice to the respondents. The petitioner shall take steps for issuance of notice.
By ordinary manner.
On the respondents.
By ordinary manner.
Ordinary means?
Ordinary general through process.
Through usual course.
Yes.
Let this matter be listed after 4 weeks.
Your lordship, item number 40 may be fixed on next week, your lordship, on 24th of July, your lordship. Petitioner is also here, your lordship.
40,
Item
24
number 40.
July.
188 days of delay.
Both of you are there.
Yes.
40 matter could not be taken up for paucity of time. Let this matter be listed on
24th July.
24th July.